Yes.
I'm sorry, Mala, I could not be present personally. I have some personal difficulties. So if your lordship, item number 54,
Yes.
supplementary admission, my lord.
Yes.
My lord, can it be taken up on Friday? If it is not inconvenient to your lordship and subject to the convenience, already I have spoken to the other side lawyer.
Friday. Friday will be 13th.
Yes, my lord.
Right. Friday.
I am deeply obliged, my lord. I am deeply obliged.
Item 54.
There is an interim order.
Item 54, at the request made by Mr. Dida, senior counsel appearing with the petitioner, stands deferred to be listed on Friday, 13th. Interim orders, if any, will continue till the next date fixed.
I am deeply obliged, ma'am. Deeply obliged.
May I please the lordship? I am paying for listing of one WPC number for orders, my lord.
For orders. For orders, let it come on 16th.
Yes.
Okay.
Similar prayer of this matter, let it be on 17th.
17th. All right.
Lordship, my lord, may I pray for listing as motion tomorrow, lordship? I filed it on 5th, lordship, regarding the selection.
Not tomorrow, day after. Day after.
My lord, I am paying for moving a motion unlisted today, my lord.
What is the urgency?
My lord, the petitioner was imposed a penalty after a due departmental proceeding. And on 3rd of February, again, my lord, new inquiry officer has been appointed.
That can wait. When is
And
it?
no, my lord, today I have been asked to appear for hearing.
You appear.
No, my lord, department.
What was the urgency that it has to be taken unlisted today?
My lord, because
We'll have to hear the matter whether the second inquiry, first inquiry
inquiry was submitted.
is even terminated.
No, not terminated.
Hmm?
That's why, my lord, why should I pay the order?
That's a different issue. Why should
Tomorrow,
you go? If you don't want to go, don't go. Your call.
My lord,
But to say that this is an urgent matter which can't wait for 2 days,
tomorrow then, because
Day
today was
after.
the hearing.
day after tomorrow. Today is Monday.
Today is Monday.
Miscellaneous days are Monday, Wednesday, Friday. So
Tomorrow,
I'm giving you the next available date.
right?
Not tomorrow. Tomorrow we've lined up some hearing matters. We have to deal with hearing matters also. What is the urgency? That's why I'm trying to understand.
Today is the date, they will take my lord coercive action.
What coercive action?
Nowadays,
What coercive action? We need not give you, tell you how you should handle these matters. Day after tomorrow.
May I please, your lordship? Lordship, I beg to mention item number 25, your lordship.
25.
Yes.
Yes.
The concern of the other side, your lordship.
Uh,
May we be listed after 2 weeks if possible?
25 on the consent of the counsel for the respondents, Mr.
Teach it.
P3 submits that the matter be listed after 2 weeks. Prayer made is allowed. List again after 2 weeks. List on 27th February.
Lordship, can it be on first week of March, my lord?
MS MD Boral and counsel appearing for the transport submits that the matter should be listed in the first week of March, list on 6th of March.
I'm so deeply
March.
obliged.
May
Yes.
please, your lordship, there is an order matter for stay vacating applications. Can it be listed on 12th?
12th.
Yes, your lordship.
Stay vacating, you have filed it.
I filed it on 27th of January, your lordship.
It's not listed.
Not listed.
This is the first time you're asking.
Yes, I'm praying for the first time for listing of the
Then
stay
we
vacating.
will list it on a miscellaneous day because notice will have to be issued.
No, the other side is there, petitioners is there.
You're filing a fresh IA which has come up for the first time
Yes,
or
sir.
which is likely to come up for the first time,
Yes, your lordship.
right?
Yes, sir.
So whether the other side is there or not, the court has to issue notice, something has to be done, giving them an opportunity. Right? So let it be on either 11th or 13th.
Okay, let it be on 11th, your lordship.
11th.
Deeply obliged.
Praying for listing of admission matter, any date lordship.
Admission.
Any date lordship.
What matter?
Termination of service matter.
Admission matters. 25th.
Much obliged, lordship.
May please, your lordship, I beg to mention item number 5, lordship. I have already taken consent from the respondent side. Lordship. Item number 5.
You are for the respondent.
And for the petitioner, lordship.
Petitioner. Item 5, on the request made on behalf of the petitioner stands deferred to be listed after 4 weeks.
2 weeks.
We list again on. এবার করে দেবো। List on 11th of March.
Obliging.
Visual lordship, lordship, I'm praying for a matter for admission lordship on Friday, possible lordship.
Admission on Friday,
Lordship,
not on Friday, 18th,
lordship.
18th.
May I please, Your Lordship?
Yes, yes.
May I please, Your Lordship? I pray for listing of the recognition the admission column 2023 matter, promotion matter, Lordship.
Promotion matter.
The first week of March, Lordship, any
First week of March.
Lordship,
First week is already cramped up. Second week,
Lordship.
9th, 11th.
Lordship,
Which one?
11th of
11th of March.
Lord, obliged.
Yes.
Lordship, praying for listing for motion, lordship.
Motion.
Motion.
When was it filed?
You are already WC filed in the during the pendency of the WBC main case. The relating to matter of the commercial vehicle. The recovery agency during the pendency of the case.
What is the matter about?
Lordship,
What is the matter, subject matter?
submitted, a default of payment commercial vehicle.
Commercial vehicle.
Yes, sir.
That will be bench 5. You go and mention before bench 5.
Then on the last date,
This is
the
bench
last
3.
date, yes.
This is bench 3.
Yes, on the last date, WBC did this.
Wait a minute. You go and talk to the court master, they'll explain to you. Yes.
Lordship, I am praying for listing of a fresh matter, my lord. It's a matter relating to appointment of junior engineers, my lord. New matter, my lord.
What is
Appointment,
the subject matter?
service matter, my lord. Appointment of engineers, my lord.
So when was the matter filed?
My lord, it was filed today, my lord. Results will be declared, my lord, and
When was it filed?
today, my lord.
Today.
Yes, my lord. The urgency is that, my lord, appointment letters will be issued on 11th, my lord. So I am praying for listing it tomorrow, my lord.
No.
Very urgent, my lord.
No, it can't be. What to do? We'll challenge, you challenge the results. If you
Otherwise,
don't
my
get
lord,
it, why are you apprehending that you are not going to be selected?
My lord, already result has been published, my lord.
Published.
One of my papers has not been evaluated, my lord.
Very well, not tomorrow. 11th or 13th?
11th, my lord.
11th.
May I please lordship? I kindly request you for listing of my writ petition.
Louder, louder.
May I please lordship? I kindly request you for listing of my writ petition for admission.
Admission. What is the subject matter?
Subject matter. It's a matter of lordship Gau Pradhan case.
Gao Pradhan to court. 5. It is civil bench 5 or 4 or something like that. Gao Pradhan civil bench 4 or 5. Yes.
May please, Your Lordship. Lordship, I beg to mention for listing of 2 matters, one for motion and another for orders, Lordship.
Subject matters.
Lordship, the motion matters pertains to non-payment of enhanced monthly wages, Lordship. It was filed on 6/1/2026, Lordship.
Fresh matter.
Lordship.
Some defect must be there. Otherwise
Lordship,
it will
we have
come.
checked.
Huh?
We have checked, Lordship. The online is not showing there is any defect or not. We have checked, Lordship.
You go and inquire in the filing why the matter has not been listed.
Lordship, we have already checked. Neither it has been numbered nor it is showing any defect, Lordship. On Wednesday, Lordship.
You give the details to the court master, we'll check.
Lordship. Lordship, and the orders matter, Lordship.
Order matter,
Regarding family pension, Lordship.
family pension, let it be on 16th.
Lordship.
I'd like to mention item number 45, Your Lordship. And for the respondent, Your Lordship, DC Bora, Your Lordship, is not keeping well today, Your Lordship. I've taken the consent from the other side, Your Lordship.
45.
Yes, Your Lordship.
I am for the petitioner, my.
Any objection?
No, my lord.
45 on the request of made on behalf of the learned CGC, matter stands deferred to be listed after 4 weeks. Mr. V. Kumar, learned counsel, appears for the petitioner. List this matter again on 11th of March.
Diploma.
May I please? I pray for listing and admission matter, then retirement benefit matter. Matters relates to retirement benefit, Your Lordship. Last week.
First week, second week, 11th March,
Lordship, I beg to mention item number 28 matter.
28.
I'm seeking adjournment for the day matter. Where the leading counsel, his child got
Suddenly ill today in the morning.
Who?
His child got ill, my lord.
Who?
B. Chaudhary's leading councilman.
A prayer is made on behalf of Mr. B. Chaudhary, counsel for the petitioner, that he is unable to attend court because of some medical.
Can it be on 16th, my lord?
On?
16th or 17th?
Prayer is made to have the matter listed on 16th. Prayer made is allowed, list on 16th. Yes.
May I pray for listing of a matter for motion? Actually, what I'm praying is that on the motion date, I'll pray for mediation. My husband died, amount is not released by the bank. Petition filed. Honorable Court said, kindly go and come back. They will respond. They still do not respond. And they would take on a fleeting that he had married again.
What happened to that writ petition?
That petition was disposed, saying that you go back and come back if they don't say. They have not said anything. But I know that my husband had married again. I've also
Orders are required to be, you are asking for a listing of matter today.
No. Conveniently, so that at least 50% even if I get.
It's a fresh matter.
It's a fresh matter.
Let it come on 13.
13th, my lord, I would be praying if Lordship permits me.
11.
Yes.
11.
May I please, Lordship? My lord, I have the instruction to withdraw the writ petition.
Mr. M.U. Mahmood, learned counsel for the petitioner, submits that he has written instructions to withdraw the writ petition. Accordingly, the same stands dismissed. It's not pressed. Dismissed on withdrawal. Interim orders, if any, stand vacated. Pending IAs also stand dismissed.
In this matter, my lord, I was directed by the Lordship, my lord, to obtain instruction whether order 6/9/2024 in contribution number 31.
No, this was mentioned just now. It was mentioned earlier.
Oh.
Oh, okay. Sorry.
Contempt, my lord. Well, I wrote to the my lord, authority, my lord, I have to receive any instruction, whether they have complied with or not.
All right, when can you get it? When can you get it?
My lord, after 4 weeks, my lord.
4 weeks.
After 4 weeks. Again, I will have to write, my lord.
None represents a writ petitioner. You're there?
Yes, Lordship.
He's asking for further time. Mr. T.C. Zutia,
Fixed date be given.
learned additional senior government advocate, prays for further time to complete his instruction. Mr. S.P. Chaudhary, learned counsel, appears for the petitioner. There's no prayer made. Please, this matter again on 16th, 16 March.
16.
I need some more time. In fact, no copy has been served to me.
Mr. N. Upadhyay, standing counsel, prays for further time as no extra copies of the petition has been served on the petitioner, on the respondent by the counsel for the petitioner. What? Your name? Please serve extra copies today. Mr. K. Kolita, counsel for the petitioner, assures the court that he will serve extra copies to the standing counsel within 2 working days. Yes, serve it.
In case we have filed IM, let the matter may come day after tomorrow.
Day after tomorrow.
Yeah, 11.
Some IA has been filed.
Yes, I am.
Mr. B. Sinha, learned counsel for the petitioner, submits that an IA has been filed in the matter. He therefore submits that the matter be listed together with the IA file on 11th.
Yes.
Mr. B. Gogoi, additional AG Assam, and Mr. R. Sinha appears for
Respondent number 5.
respondent 5. List on 11th of February. Along with the IA.
Dada, copy diya na, ma.
Claim now, that's on my
Lordship, my senior is at Lex, may it be taken after some time.
Third, learned counsel for parties issue notice returnable 4 weeks. Steps on the sole respondent by registered post. Matter be listed again after the returnable date on 16th of March.
Same would be for item number 5, Lordship.
Item 5, someone mentioned.
This contempt is against the interim order, my lord. Direction was issued not to publish the select list for the post of Anganwadi helper. But in spite of that order.
What has happened to the
Writ
writ petition?
My writ petition is pending fiction 20 February.
20.
Yes.
Then let this contempt petition be listed along with the writ petition.
Yes,
Let this contempt petition be listed along with WPC number
158 of 2025.
158 of 2025. As this contempt petition is filed for willful disobedience of the interim orders passed in the same matter, it is submitted by the counsel for the petitioner that the writ petition is fixed on 20 February. Accordingly, let this contempt petition be also listed on 20 February.
Notice, ma'am. Notice has not.
No, let it come.
Yes.
Yes.
Wait, Lordship, this is a contempt matter. And
Where is the order?
Lordship, page number, the operative portion is in page number 20, Lordship. First page.
Where is it?
Lordship, page number 20, first para.
First para.
Yes, Lordship.
Read it.
Accordingly, the petitioner having been found to be entitled to authorized family pension and other pensionary benefits, this court directs the respondents in the Public Works Department, more particularly the Executive Engineer, PWT, Maibong Division, Maibong Dimahasao, to process the family pension proposal in respect of the petitioner and submit the same before the Accountant General, Assam, within a period of 2 months from the date of receipt of a certified copy of this order. The petitioners shall cooperate with the respondent authorities in the matter for an early conclusion of the preparation of the proposal for authorizing to her family pension and other pensionary benefits. On receipt of the family pension proposal in respect of the petitioner herein, the Accountant General, Assam, shall process the same and authorize the family pension and other pensionary benefits to the petitioner within a period of 1 month from date of receipt.
Yes, yes.
And Lordship, we have preferred representation on 19-2. So the time granted has
Notice
lost.
returnable 4 weeks. Steps on the respondents by registered post. Sorry, speed post within 2 weeks.
Object.
Yes, it is a contempt petition, my lord. My lord, the order is 12 to 18, and my representation was given, my lord. The order, they said that 1 month apart. But 4 months have been passed.
Where is that direction?
Direction.
Page number.
Last page, my lord. But it is for para 14th order of the.
Third, learned
I find that
issue
I
notice
find
return
made in the
4 weeks. Steps on the respondent by speed post within 1 week from today. List this matter after the returnable date. List on 11th March.
all of them.
Right.
Please, Your Lordship. Lordship, this contempt petition is filed for compliance of order dated 9/9/25, Lordship. Order is at page 9.
Page 9.
And the direction is at page 13, Lordship. Para 8.
At counsel for parties, issue notice. Return of 4 weeks, steps on the respondents by registered by speed post within 1 week from today. Placed after return to date on 11th March. Yes.
Please, Your Lordship. Your Lordship, earlier occasion in a writ petition in page number 56, Your Lordship had passed an order for closing of the representation, Your Lordship. Thereafter, the representation has been closed. Last order is in page number 56 and 57, Your Lordship. 56, Your Lordship. Page number 56 and 57, Your Lordship.
Then,
Your Lordship, thereafter the representation has been closed. The issue was with regards to a lady applying for the post of Anganwadi worker. They selected her for the interview. After the interview, when the final merit list was out, she was rejected on the ground that she was the single candidate who has appeared. However, there were no such preconditions given. Thereafter, we filed a representation. The Lordship had asked for the disposal of the representation from the department. Accordingly, in page number 60 and 61, the department has closed the representation. May I read last paragraph of page number 60, Your Lordship? Page number 60, last paragraph, Your Lordship. Whereas there is no specific reference in the guidelines issued by number SWD this dated 25/1/2019 that if any center there appears single candidate, then re-advertisement should be done. This is the department, Your Lordship. However, in the interest of fair competition and to bring out best candidate, in earlier cases also directions for re-advertisement were issued from this directorate. In such situation, the single candidate can again apply for the same position. In case if no eligible candidate turns up second time and only one candidate appears, then she will be selected for the position and approval will be accorded, Your Lordship. Under these circumstances, the submission made in the public petition dated so is not entertained in application of Maspia Khatani is advised to participate in the selection process if re-advertisement is.
So there was an advertisement.
There was an advertisement, Your Lordship, and against that advertisement, we have applied for the post of Anganwadi worker, Your Lordship. Thereafter, based on the scrutiny of documents, our application was accepted and we were called for interview, Your Lordship. We appeared in the interview on the due date and the due time. After that, we cleared the interview and our name was published in the final merit list, Your Lordship. In the final merit list, after our name was published from the directorate, it was crossed as in bracket single candidate, we cannot take her. Thereafter, we filed a representation and they said that at the time of advertisement, there was no such regulation. And even today, there is no such guidelines which prescribes that if there is a single candidate, then her candidature should be rejected after the final merit list, Your Lordship. And thereafter, when we have filed a writ petition and the direction was given for the disposal of the representation, this is the reply which they have given, that there is no specific guidelines. However, just for the case of fair competition, we are rejecting her this time. She can again apply next time and get the post, Your Lordship, if no other candidate appears, Your Lordship.
No, Lordship, it is on the basis of the precedent, Lordship. Where there is no specific guideline that the precedents avail, Lordship. Here in this case, Lordship, in our earlier precedents, Lordship, we re-advertise in various occasions, Lordship. That's why her representative
basis you are claiming your rights.
Your Lordship, page number 33, Your Lordship. Come down, page number 33, Your Lordship.
No, facts we have understood. It shows the law.
Yes.
Your Lordship, it shows the law that there is no such requirement even when there is a single candidate that there are CVC guidelines, but of course they may not be with regard to Anganwadi workers. But this is for how many centers?
This has been done for 4 centers, Your Lordship.
4 centers.
What
happens to the other centers?
In other centers, Your Lordship, there are more than one candidates. They have been taken as per the interview and the result, Your Lordship.
So you go for a fresh advertisement?
Here, Your Lordship, we have one submission to make, Your Lordship. At the time of application, there were 3 candidates which they have applied, but we do not have that record. That record will be with the department, Your Lordship. Based on the 3 to 4 candidates who have applied, scrutiny was done, and my documents were cleared for the interview, Your Lordship.
Is there a reject list?
There is no reject list. That is the difficulty, Your Lordship. There is no reject list. Moreover, Your Lordship, in page number 33, in the advertisement itself, they have given 5 criteria under which it may be rejected, Your Lordship. Your application might get rejected. Here also, there is no specific mention.
Your question is that single candidate has been in spite of the selections we made, single candidates have not been allowed to be appointed on the
Indeed.
ground that it's a single candidate,
Indeed, your lordship.
right?
Indeed, your lordship. In that case, our right is directly violated because we have completed entire procedure, your lordship. Thereafter, a department takes a discretionary decision that will not allow single candidate. That would have been told us prior or at the time of the advertisement, your lordship.
Okay.
That is a discretionary
The
decision
notice
taken
may go
abruptly.
at this stage, lordship, notice may go, but
No, what notice you show us that, show us the records, give us the records,
lordship.
get the report, that will issue notice, heard concern for party, lordship, that's it, then about the weeks. Mr. Goswami, J.K. Goswami appears for all.
Lordship,
Appears
accept
for
the
all?
private respondent here.
Huh? There are no private respondents.
Oh, I think, oh, it's not.
Appears for all the responding.
All the-
This is a waiver of the service for the notification public from today. Respondents are permitted to complete their instructions and file necessary affidavits. If so advised.
That's fine.
Lordship, the petitioners are the Anganwadi workers, and in addition to that, Lordship, they were engaged as BLOs, and they were continuous in their service as BLO as well as Anganwadi workers. But subsequently, Lordship, by recent notification, they have been dropped from BL, and thereafter they have filed a representation page 52 and page 54, Lordship.
Then what happened?
Lordship, now Lordship, the representation is still pending.
Please get
Lordship,
instruction.
kindly have a look at Annexure H, Lordship.
Annexure
H, Lordship, page 56, Lordship.
56.
Lordship.
Hmm.
Kindly see the letter received. No, Lordship, government has decided to the Anganwadi workers in works outside, not to work in Anganwadi workers in works outside the ICDS and women related issues, Lordship. In that issues, Lordship, I have received the instruction, Lordship, that in central government also, Lordship, decided not to engage Anganwadi workers in outside the Anganwadi centers, Lordship. And central government decided on 5/11/19, Lordship. After that, the state of Assam also decided not to engage the Anganwadi workers, Lordship, in BLO related issues, Lordship.
You bring it on record.
Lordship.
File an affidavit.
Lordship.
Bring it on record. The counsel for the petitioner, the respondent submits that he is posted with the necessary instructions. He'd like to bring it on record. Prayer made is allowed at this stage without issuing notice, as the learned state counsel submits that he is posted with the required instructions. List again after 2 weeks,
Lordship.
enabling him to file the necessary affidavits. Meanwhile, extra copies be furnished within 2 working days. List again on 25th. Can you bring it within 2 weeks? 27.
27, Lordship.
26.
Obliged, Lordship. Obliged.
It would be good.
May I please, your lordship? As a petitioner before your lordship is a ex-serviceman of Jammu and Kashmir Rifle, lordship. This petition is relating to the rejection of the name of the second wife in the service book, lordship. The impugned order, lordship.
Is there a divorce?
Yes, after the divorce, lordship.
Where is the divorce order?
Yes, divorce also, lordship, fine.
Before
Page
my
number.
friend, my learned friend submit, Lordship, section 14 of the administrative Assam, let's say Armed Forces Tribunal Act may be seen. He has to approve the Armed Forces Tribunal.
He's a retired Havildar.
Retired Havildar, lordship, and divorce order, lordship. Your
Section
lordship,
14 may be seen, Lordship.
1/4.
1/4. May I read, Lordship?
Yeah.
Save as otherwise expressly provided in this act, the tribunal shall exercise on and from the appointed date all the jurisdiction, power and authority exercisable immediately before the day of all courts, so and so, in relation to all service matter. Now, Lordship, service matter has been defined under 3O. Three O.
3O.
3O. Service matter in relation to this person subject to the Army Act and the Air Force Act, meaning all matters relating to the condition of their service and shall include remuneration, pension and other retirement benefits. Now he is for the retirement benefits and pension.
Where is it?
301.
Pension also.
Pension. Pension also included, Lordship. Let him approach the Armed Forces Tribunal.
But in this case, Lordship, the retirement benefit of my wife, Lordship. Wife and children's we get on from the second wife, Lordship. After my wife, Lordship. Only my wife's name has been not included in the service book, Lordship.
Whose service book?
My service book. Lordship.
So you are an employee under the
Yes.
JKF?
Yes.
What is it? You are JKF rifle.
Yes, sir.
And moreover, he has implemented the
What is JKF rifle?
Jammu and Kashmir.
Jammu and Kashmir.
That I know, but what is paramilitary?
No, fully armed forces. The
Okay.
infantry division, Lordship.
You have to approach the Armed Forces Tribunal.
Lordship, then yes.
The
Objection, Lordship, maybe.
learned CGC, Mr. B. Chakravarti, appearing in the matter, has pointed out that under the Armed Forces Act, as per definitions, as per section 3, within bracket O, and section 14, say that all service matters pertaining to armed forces are to be filed before the Armed Forces Tribunal Act 2007. So the issues raised by the writ petitioner in the present writ petition is inclusion of the second wife of the writ petitioner in the pension papers of the writ petitioner. And again, the issue here is the non-inclusion of the name of the second wife of the writ petitioner in the pension papers of the writ petitioner, and being agreed, the present writ petition is filed. Perusal of the relevant sections of the Armed Forces Tribunal Act 2007 reveals that the matter ought to have been filed before the Armed Forces Tribunal Act, Armed Forces Tribunal. Mr.
R.
Borua, counsel for the petitioner, fairly submits that he be permitted to withdraw this writ petition and file the same file it afresh before the Armed Forces Tribunal. Accordingly, as prayer made, writ petition stands dismissed on withdrawal, permitting the petitioner to approach the Armed Forces Tribunal in Gauhati and petitioner is permitted to file before the Armed Forces Tribunal and pursue his claims accordingly. Dismissed.
May I please, Your Lordship? Matter relates to recalculation of basic pension and gratuity, Lordship. Already, petitioner was already appointed as, initially appointed as master roll worker, Lordship. Thereafter, his service was regularized as master roll worker, and thereafter, he was promoted to assistant electrician, Lordship. Lordship, already similar order has been passed, Lordship, regarding recalculation, Lordship.
Do you have a copy of that order?
No, Lordship.
How many similar orders? Read your full copy. The State Council. Sanjita Roy order.
Lordship.
Right. Yes, heard discharged. You go through, Mr. Upadhyay, if there's anything, let us know. It's
Sir,
that the addition of these years of service rendered, which is upheld by a division bench. order.
Item 18 also, Lordship.
Item 18 also.
Okay. Six petitioner, item 18.
Okay.
Lordship fixing, not today, Lord.
We are disposing it off.
Dispose.
You go through the order, if you see that it is not covered, you point out.
Lordship, all right.
Take to correction, we are disposing it off.
All right.
Because we have gone through and we find that it is covered.
Oh,
But we give you that liberty.
Lordship.
So related to promotion of the petitioner and the gradation list. Page 41.
You are seeking promotion.
Yes, yes. Updated gradation list because my lord, I am senior than the private respondent in terms of joining of the my lord. This
I heard Mr. So-and-so learned counsel for the petitioner issue notice returnable 4 weeks. Mr. J.K. Goswami, additional
1 to
senior
4.
government advocate, appears for respondent number 1.
1 to 4.
1 to 4. Therefore, notices are waived. Extra copies will be furnished within 2 working days. Steps on respondent number
5
by registered post within 1 week from today.
Remember, the petitioners were terminated. They claim for termination and regularization. Industrial dispute was raised against the termination as well as regularization. But while referring the dispute, appropriate government did not refer the issue of reinstatement. The termination issue was not referred. If they would not be reinstated, regularization. Okay, so we are praying for additional issue, referring additional issue regarding their whether termination is justified or not.
What is pending now?
Now at the stage of written statement, initial stage.
No. For what? What is the dispute?
Now it is pending, Lordship will.
Where is the dispute raised?
At page 31, the appropriate government has referred the dispute. Page 31, the schedule, terms of reference, whether the applicants see so and so have been performing continuous and perennial nature of work which is integral to the functioning of Airport Authority of India through camouflage sham contract system and are entitled for regularization in service from their date of joining with back wages. If so, what relief the applicants are entitled to. But they are terminated. If that is not adjudicated, regularization without reinstatement, the issue of termination is required to be adjudicated, my lord. That is our limited prayer.
Who's for, where is the CGC? You are already terminated.
Terminated.
What is the point in going with the reference?
That is because the issue of termination is required to be referred. That was not referred. That is
you
my
were terminated after the reference.
No, my lord, the case is that petitioner number 3 was terminated before reference. And they raised the dispute against that termination as well as for regularization. But once it was closed by the conciliation officer on the ground that there is no employer-employee relationship, but conciliation officer cannot do that as per section 12 of the Industrial Dispute Act. It is to either to conciliate, and if conciliation failed, then to submit the failure report. Again, they submitted application before the Secretary Union of India, Department of Labor, and it was transmitted to the conciliation officer, and conciliation officer hold the conciliation again. After conciliation, it was failed. That after failure report was submitted. 23/9/2025, Annexure 4, page 29 is the proceeding of conciliation, latest conciliation. Failure report was submitted before the appropriate government, but appropriate government, while referring the dispute, the termination issue was not removed.
Failure report, while the failure report was submitted, you are already terminated.
Yes, ma'am.
Then what is the failure report?
At page 29, my lord. Relevant
You
portion.
have not appeared before the labor court.
Last appearance, we have appeared and filed application for checking time. Now 11th is the next date. If that issue will not come, my lord, their reinstatement, the adjudication would be.
Is there any, what is the ground for the failure report primarily?
That is not mentioned, my lord. Page 30, paragraph 7. However, both the parties have divergent views over the said dispute matter. Therefore, despite best efforts of conciliation officer to resolve the matter, the dispute could not be settled and the conciliation ended in failure. Hence, conciliation proceeding is hereby closed. So thereafter, government referred the dispute. It is at page 31.
During conciliation, you are terminated.
No, my lord, when the first conciliation was closed on the ground that there is no employer-employee relationship, after that, 1 and 2 were terminated. 3 was terminated earlier. 1 and 2 were terminated after that. Then they applied before the representative, before the secretary, Labor Department, Government of India, and Labor Department transmitted that representation to the RLC Gauhati and conciliation held. After that, this Annexure 4.
Where is the communication of the Labor Department to the RLC?
That is the.
Now, the page 27 is what?
That communication, page 27 is our representation before the Secretary, Government of India.
When was it filed?
It was filed on 11/6/2025.
11/6.
11/6/2025, page 27.
This is after your termination?
Yes, my lord.
You have not raised this issue?
My lord,
that you were terminated?
That, my lord.
Page 28, your.
Page 28.
Is
my lord,
only regularization, back wages, etc.
My lord, one thing is that that retaliatory termination, column 3, page 28, prayer part column 3, issue necessary directions to prevent retaliatory termination of workers.
Yeah, to prevent.
First, my lord, in wordings, the workmen have failed to.
That's the core issue.
Explain that, my lord.
That is the core issue. If your termination is not under consideration,
that
where is the
exactly.
question of regularization now?
But during conciliation, that issue was discussed. But
even in the failure report, it is not.
Failure report, that is not mentioned, my lord. Nothing is mentioned. What was the issue?
Then?
Nothing
So
is
the
mentioned.
issue will be the prayer you have made here. Issue would be 28.
Yes, my lord.
Last paragraph.
Yes, my lord.
That is the issue. It doesn't refer to termination.
But my lord, this earlier, when they applied that termination issue was mentioned, but categorical prayer is not there, my lord. And that type of prayer was.
No, categorical or presumed indication, whatever it may be. But the fact is that the departmental officers proceeded on your prayers made. There was no prayer for interference with the termination order.
Only
prayer was for regularization. You were terminated in the meantime. So they say regularization or divergent views, this, that matter is now.
Problem is that, my lord, if the issue of termination would not be adjudicated, then question of regularization, that would be futile exercise.
No, no. The whole reference is irrelevant.
Yes. That
then
until and unless the issue of termination would not come, this question of regularization, that's our prayer, my lord. The poor workmen, it can be referred only that additional issue I am
Yes,
paying.
madam. Can you get instructions?
Yes, Lordship. We are appealing for Labor Commission, Lordship, not Airport Authority.
No, the airport is irrelevant. The airport is the employer.
Yes, Lordship.
Now the issue is before the labor court.
Yes.
Issue is with regard to regularization and other
Yes,
players made.
I have to
But
take
they have already been terminated, and termination is not the issue.
Yes, Lordship.
So what orders will the labor court pass? How they cannot deliberate on the issue of regularization when the petitioners have already been terminated.
Yes, Lordship. I have to take instruction, Lordship.
Please do. Third counsel for parties, the learned CGC MSS Purva, we submits that she would like to obtain instructions in the matter. The petitioners were employees of the airport authority and they were working on contract.
Contract labor.
Contract laborers. And they demanded regularization of their services. The matter was referred to conciliation. And upon conciliation being failed, the matter was referred to by the government, was referred to the labor court. And at present, matter is pending before the labor court.
CGIT come labor court. CGIT come labor.
CGIT come labor court. However, however, prior to the failure report submitted by the conciliation officers, the petitioners were already terminated from service. And this aspect was not considered by the conciliation officer. And as a consequence, the termination is also not an issue before the labor court. Learned counsel will obtain the required instructions and apprise the court the next day. Extra copies be furnished within 2 working days. List this matter again on 11th.
11, day after tomorrow.
March.
March 11.
11 March.
Yes, that's
Well, and till then, my lord, the proceeding before the CGIT is required to be.
You go and apprise the CGIT. You have already filed WS.
No, I have not filed WS.
To go and
It is
file
the first
WS.
that. So, if that is not, if it will be proceed, you know.
In 1 month, how many orders will be passed? How many orders do you think will be passed by the labor court?
Mal.
To come back and apprise us.
Mal.
obliged.
Yes.
My lord, petitioners, they are advocates, my lord. One, my lord, already served as an assistant PP for 5 years. My lord, they, an advertisement was issued for, my lord, 26 number of PP, 88 number of additional PP, and 185 number of extra PP post. And they applied for a post. They were selected in the first list, my lord. Because they were called for interview as well as, my lord, professional test. Thereafter, my lord, police verification was done. Subsequently, my lord, they have published a list of 181 candidates, my lord, for the post, where, my lord, their names taken appear.
There was a written test.
Proficiency, vivacy and proficiency test.
Vivacy
and proficiency test.
So proficiency was held earlier or Viva was held earlier?
My lord, jointly it was done.
Jointly. So you said you were in the first list.
Yes, in the first list. 3 lists were prepared. First list, second list, third list.
Third list.
In the
So
first list, we are there.
first list you are called for.
We are, police verification was done, my lord.
Oh.
And thereafter, my lord, it appears, my lord, from the first list was,
41 candidates.
huh?
241 candidates.
241 candidates were there. My lord, their numbers are there, my lord, they mentioned. So, we are not appointed.
So what is your?
My lord, my grievance is that, my lord, we are in the first list, my lord. We are selected, my lord. Our serial numbers are there. 81 to 11.
Where is the list?
My lord, list is not here given to me, my lord. We have seen our numbers. We have mentioned in paragraph 7. Paragraph 7, if you are also see, my lord.
Is it on the basis of merit?
Merit.
No, this list is for what purpose?
For the purpose of, my lord, appointment, my lord, of the.
After the proficiency and vivacy.
Paragraph 7, my lord, if you also see. The first list contains 245 lists. My lord, this line about 5th, my lord. Thereafter, when the petitioner approached the respondent authority. Para 7, page 10.
7.
Petitioner stated that subsequent to completion of the vivacy and other stages for the selection process and the petitioner's performance in the said process, the petitioners were quite confident that there was strong legitimate expectation being selected the post. Thereafter, when the petitioner approached the respondent authorities inquiring about the outcome of the selection process, petitioner was shown a past list containing 245 name of careers, wherein petitioner number 1 was CL number 81, 2 was at 211, 3 was at 116, and 4 was at 75. Two more lists were there, second and third list. And thereafter, they were called for police verification, right website. And after that, my lord, they were not appointed.
A list was published, my lord, that list we are having, my lord. That the 181 candidates were appointed, my lord, page 44.
Yes. I have to take instruction, please, sir, individual case.
Person, sir.
Heard Mr. G. N. Saibulal appearing the petitioner.
Only a notice may be issued at this stage.
My lord, only I pray, my lord, the 4 posts may be kept vacant. There are many number of posts, my lord, because about 299 posts were there. 181
If
list. was-
that be the case, then I would like to argue that his own practicing certificate has no validity when the interview, if lordship is pleased to come to.
So we'll do one thing, we'll not issue notice.
Well, okay.
We will permit your government advocate to obtain instructions.
Yes.
And you address the court, we'll issue notice on the interim prayer also.
Yes.
Let
But,
it come on Friday, lordship.
Friday, Monday, whatever day
Yes.
you want.
On instructions, I can bring on Friday.
Friday.
Heard Senate Counsel for parties, the writ petitioners are practicing lawyers who had submitted their candidatures to the advertisement issued by the state for appointment of public prosecutors and assistant public prosecutor. What is that?
Various posts, my lord, the different posts, because the petition number 1 applied for additional and assistant PP.
For appointment of PP, APP, there's no PP post, right?
PP post is also there, man.
PP,
PP, petition number 2.
And assistant
Additional
PP.
PP, assistant PP.
Additional PP, assistant PP and PP. Three category.
Three. Petitioners had applied for the various posts. Although according to the petitioners, according to the petitioner council, their names appeared in the select list. First list of what?
Well, first list, 2, 3 lists are published.
What list? Select list.
Police for police verification, my first list.
Select list, only one we have published, which is in public domain.
The lists which are published by the respondent state for police verification. Subsequently, the select list was published wherein the names of the writ petitioners were not reflected, being agreed the year before the court, challenging, seeking a direction to the respondents to ensure, seeking a direction to the respondents to consider the, to consider and issue appointment orders to the writ petitioners. Mr. D. Saike, learned Advocate General Assam, submits that this matter be posted on Friday or Monday.
Let it come on Monday.
Monday. And on which dates you would like to address the court on the issues raised. Stop. Meanwhile, Mr. D. Nath, learned senior government advocate, will obtain the instructions. So although notices are not issued, extra copies we furnished. Can it be done within the course of the day?
Yes.
Within the course of the day. Here, the list again on Monday. That is on 16th of February.
Highly obliged. There is another identical matter at 51, but the petitioner side counsel is not here.
51.
My colleague will be appearing, lordship. Same kind of order may be first.
We'll
Identical
fix it on
case.
16. We'll fix it on the same day.
Same date, lordship.
Yes, Mr. Dasgupta.
71 or 70? 70.
Yes.
But your lordship, this matter pertains to an executive order whereby the inland, All Assam Inland Water Transport Corporation Limited has been vested with the power to carry with the business.
Who are the petitioners? Union.
Union as the petitioner.
Where is the executive order?
First at FPA, Annexer A, my lord.
Annexure A.
Page 25. Page 25. Pursuant to the approval of the cabinet by numbers, the governor of Assam is pleased to transfer and vest all the fixed and floating assets under Annexure A and liabilities at Annexure B presently under possession and control of the Directorate of Inland Transport Assam and Assam Inland Water Transport Development Society on as is where is basis, including but not limited to the vessels, building, land, terminals, jetties, and other associated infrastructure developed or constructed mentioned in Annexure A and B as in where basis. Well, earlier, we had an occasion before to approach before this court, my lord, on the same issues, my lord. And this court also passed an order.
No, how are you affected by the transfer? How are you aggrieved by the transfer? There is a company floated. The responsibilities of the department are now on the company.
Lordship, come to page number 26.
26.
There is a consequential effect. In the interest of public service and with the objective of ensuring the efficient, coordinated and effective functionings of the inland water transport sector in the state of Assam and in pursuance of the decisions of the Honorable Cabinet covered by number such and such, the Governor of Assam is hereby pleased to constitute a committee to examine, consider and recommend the attachment, that is very much important, the attachment and deployment of officers and the staff of the Directorate of Inland Water Transport to various organizations. These are the person concerned 1, 2, 3, 4. The committee shall have the following mandates: to assess on ghat-wise, vessel-wise and office-wise basis manpower requirement of the existing Directorate of Inland Water Transport Assam once the function assets fixed floating but not limited to the vessel buildings and land terminals, jetties and other associated infrastructure developed or consumed under DIWT are notified to be referred to assess manpower. No, your lordship. Now, here, my lord, to assess the manpower of requirement.
This assessment was not done.
No, that has not been done.
Not done.
Not done. Not yet done. Now, my lord, one thing, lordship, may very much clear. Your lordship come to Annexure C. At one point of time, the similar order was issued. And we had an occasion to approach before this court with the same plea that we have adopted before your lordship.
What we don't understand is that this entire transfer to the company was pursuant to some MOU between the government and the workers, and there was some MOU or some understanding, yes?
Yes, my lord. That lordship already disposed of this matter.
There was an MOU.
I don't think.
Now, the MOU was, or the understanding was the workers of the department will not be discharged. They will become employees of the company with the pay benefits and all that.
Your lordship passed an order in this regard, Lord. That is a consent order. That lordship, I can pass this order. I have brought this order. Mr. A. Ganguly.
No, you read it. You read it.
Heard Mr. A. Ganguly, learned counsel for the petitioner. Also heard Mr. D. Saikya, learned Advocate General of the State of Assam, and senior counsel assisted by me, Miss P. Burwa, learned counsel for the respondent. The read petition is agreed by the communication dated 25/7/2024 issued by the Deputy General Manager, Assam Inland Water Company Limited to the Director, Inland Water Transport, whereby intimation was given regarding the handing over process of a ferry service, Inland Water Transport Division, Silchar and Gauhati. Hilchar and Gauhati based on ferry services to Assam Inland Waterways Company Limited, so that the operational can be started by AIWCL from September 2024. The petitioner is an association. Well, we are defined association. Petitioner is an association comprising the employees employed in the Inland Water Transport Department, Government of Assam, who are agreed by the takeover of the ferry service by Assam Inland Water Company Limited. Therefore, the present writ petition has been filed. During pendency of the writ petition, negotiation took place between the petitioner's organization and the other stakeholders, including the government and the state company. An agreement was reached and accepted by the association, which is also a signatory to the minute of the meeting held on the various stakeholders. Under these circumstances, the learned counsel for the petitioner, as per instruction, submits that no further grievances survive in the present writ petition, and the same may be therefore be closed. However, liberty is granted to the association or any employees to approach this court if any such grievances still survive. The respondent have no objection to the prayer made by the petitioner. Accordingly, the writ petition stands closed. So I don't find any such agreement whatsoever.
MOU.
No such
It is
MOU.
indicated. You just read it. That you just read something that they were signatories to the.
No, that is different tuning. My instruction was that there was a proposal and one union was called to the meeting and they attended this meeting and they have signed on the minutes of the proceeding. So we are not the union, not you.
If you're not the union, you take necessary steps against that order, that you are not called and in spite of the union being there.
No, we don't feel any necessity.
All right. But what we want to know is what is your grievance in respect
My
to the.
grievance is if this law order is implemented, then our services will be jeopardized.
That is what was decided there in that matter.
No.
Yes.
Nothing was decided in this matter, blood.
Yes, that was the ground that they had approached this court saying that this transfer will put their services to prejudice. Therefore, there was some MOU or agreement between the government, the company and the workers, and they agreed that the governments gave a proposal that their service will be protected along with whatever, but they will be employees of the company. They agreed, signed, therefore the writ petition was closed.
My issue, there is no such MOU has been signed, Lord. I don't know from where.
Meeting was held and is a minutes of the meeting.
The minutes of the meeting, a discussion took place. There was no MOU whatsoever.
No, MOU or discussion or whatever, you have just read it, that they were signatories.
No, they were signatories. That is another union.
No,
A
signatories to
proposal, a
what?
proposal was made
Signatories to what?
of the minutes of the discussion.
Then?
The discussion took place. They have not given any consent whatsoever. Actually, we are not that union. We are defined union. And your lordship given specifically, your lordship given an option to approach before this order.
No, approach is all right, but what we don't understand is that once a decision is taken by the government for transfer of the assets and liabilities, etc.
Yes, that is the crux of the problem.
How is the workers' union, are you affected by that? You are affected by the conditions of your service.
Now, whether this transfer can be taken place without enacting any enactment, that is the mandate of the law, Lord. Constitution, Lord. This matter, if your lordship,
Is not in accordance with law.
this transfer is not itself is not in accordance with the constitutional mandate.
Let us see.
Now, your lordship, come to Article 154.
Yes, 154.
Is the
Yes.
Now, your lordship, come 154(1). The executive power of the state shall be vested in governor and shall be exercised by him either directly or through officers subordinate to him in accordance with this constitution. So the purport of this article clause is that all the executive power is vested to the governor. He can exercise it or it can be exercised through his subordinate officers. That is very much important. Now, come to clause 2. Clause 2, nothing in this article shall, let us keep up A, shall prevent Parliament or the legislature of the state from conferring by law function to an authority subordinate to the governor. So basically, the executive officers are the subordinate officers of the governor. Now, an authority cannot be a subordinate officer of a governor. However, for that purpose, this clause has been inserted. The nothing in this article shall prevent the Parliament to legislature or the legislature of a state from conferring by law functions on the authority subordinate to the governor. So in order to delegate some executive power to an authority, there must be a law. Now, this aspect was agitated before this honorable court. Your Lordship may kindly have a glance on Annexure 3C, which is at page 28. Same issue. The Governor of Assam, that is an order dated 17 July 2015. The Governor of Assam is pleased to notify a decision of the State Cabinet dated 30 June 2015 for incorporation of a corporation under the administrative control of the Transport Department in the name and style as Assam Inland Water Transport Corporation Limited, which is the response number 3 million, as a specific public sector undertaking under the Companies Act 2013 with the objective and structural detail in the Memorandum of Association and Article of Association annexed here, which is an integral part of this notification. The authorized share capital, initial pay up capital of the corporation will be such and such respectively. The Assam Inland Water Transport Corporation will come into existence with effect from the date of incorporation and the register of the companies. Because this order was assailed. Same thing was adopted before the court. Yeah, yes, you can do this. You can transfer your executive power to an authority. But for that purpose, an act is required. Now, your Lordship, come.
The judgment is at page 46.
Yes?
Page 46.
Page 46.
It starts from page 48.
It starts from page 48.
Page 49.
Relevant page to what?
Page 49.
59 nigga.
Initially, the fourth line, in front of. Because initially, that
Yes. As the 3 read petitioners are taken for disposal together, since the issues involved in the page 49, paragraph 2, such and such is filed by the Assam Inland Water Transport Workers Union, while 2 other read petitioners filed by the Assam Inland Water Transport Employees Sanstha and was initially filed by the said petitioner challenging the notification dated 17/7/2015. That is Annexure C. Whereby the decision of the State Cabinet dated 30/6/2050 for incorporation of a corporation under the administrative control of the Transport Department in the name and style of Assam Inland Water Transport Corporation Limited as a state public sector undertaking under Companies Act 2003 was notified. Subsequent, therefore, respondent authority in the State Transport Department issued notification dated such and such, notifying the registered officer of the corporation to be the Directorate of Inland Transport, Gauhati, Ulubari, Gauhati 7. And again, in superstitions of the same issued another notification dated such and such, notifying the location of the registered office of the Corporation of Inland Water Transport Guest House, Pandu, Gauhati. Therefore, an order to challenge two subsequent notification WC such and such was filed by the petitioner. Be stated here that the three notification put challenge and hence the common is necessitated. Now, in that case, no same type of argument was placed before the lordship. Page 58. Now, all these cases were referred and page 58.
Paragraph 15.
Paragraph 15.
15 से आरंभ करो ना, उतना ही।
Let's start page 58. In so far the decision relied upon by the learned senior counsel for the respondent department in municipal corporation, Damdam municipal, there is no argument to the fact that the state government are at liberty to embark upon the NBC system course activity were upon the civil. Under the page paragraph 16, paragraph 16.
But the same has to be backed by legislation and not.
But the same remains at the same to be backed by a legislation and not by merely by means of an executive order.
When was this order issued? This order? 27/2/2020.
27 to 2020.
And the other order?
Right, present order. This order was set aside. Only thing was that, your lordship, just come to page 59, paragraph 6. Under the facts and circumstances of this
Case,
page 59.
So what was challenged in this writ petition?
Challenge was that you can pass such an, you cannot pass such an order through an executive order. You should act an enactment. Now, I shall place another enactment below. That was passed by the parliament. That is the problem with the state government here. Under the facts and circumstances of the case and upon due consideration, I find merit of the writ petition, the state respondents having not come with any legislation. The impugned notification dated 17/7/2015 is found to be unsustainable. Accordingly, the same is set aside. Likewise, the impugned notification dated such and such are all set aside. So state government was given a liberty to come with a legislation. Now, my lord, one thing that Central Indian Water Transport.
And who are the union in the judgment, that order?
Yes.
Subsequent order? Which was the union?
Last order.
of this court.
The order passed by this court.
Same union.
Same union.
Same union.
And who is before the court?
Sanstha, not the union Sanstha.
Same union, all India, all Assam Inland Water Transport Union, even that union also there, along with this.
No, you were reading out one order passed by this court.
Yes, yes.
Who had filed the petition?
Lordship,
Another-
State Inland
another-
Water Transport
another-
Employees
What's the
Sanstha.
name of that petitioner?
Oh, name of the petitioner.
State Inland Water Transport Employees Sanstha.
State Inland Water
Inland Water
Transport Employees Sanstha. And this employee Sanstha was also one of the writ petition in the earlier case. Now, similar order, your lordship, Parliament also enacted an act. So if your lordship come to page 33. 33, model page, section 11. And
Yes.
the Parliament enacted an act, the Inland Water Authority of India Act 1985. By this act, your lordship simply come to page section 11.
There was no appeal against this order.
No, there is no appeal. Now, their contention, they have a one case below. Their contention, they have enacted an act that is called as the Act 2021.
Indian Vessel Act 2020.
Legal act, and for that purpose, not necessary. But this act is not relevant act. So I have dealt with in this petition itself.
For the setting up of the company, is there a legislation?
Yes, Lordship.
What is that?
Indian Vessel Act 2021.
That is their case. No such authorization.
Five.
Yeah, just come, I shall come to their case.
Dada,
Get on.
Where is the relevant?
if 3, I have flag more.
Yes. First is the designated authority. And section 3. Section Their case is state government may by notification, chapter 3. The state government may by notification appoint one or more designated authorities within the respective jurisdiction for the purpose of exercising or discharging the powers, authority, and or duties conferred by or under this act and the rules made thereunder. This act is enacted for all defined purpose. That will be clear from the preamble of the act itself. Paragraph 7 onwards.
Where is the constitution of that company?
Lordship, Lordship will find at page 32 of their. My lord has got it, my lord?
Yes.
May I read, my lord?
Where is that cabinet decision?
That they have not annexed. I will get that instruction. They have not challenged that cabinet decision also.
They are not required to.
Cabinet
In fact,
decision has no
Lordship,
value with it, unless it is
initially
converted to an
this-
order
This union has challenged the
under
Act
Article
of
150.
2018 before this honorable division bench.
What
This
you have done is to transfer the entire responsibilities to a company.
Lordship.
What will happen to the department?
There will be something is there, Lordship, in the page 32, my lord, will second paragraph, Lordship will kindly see. The government of Assam may by specific separate notification specify the division of powers, authorities, duties, and geographic areas between the Director of Inland Transport and the Assam.
So has it been done?
Yes, that exercise will be done, I think. That instruction I don't have right now. I will get, Lordship. I'll file affidavit. In fact, Lordship, may I submit one thing?
No, there's a question which they've raised is,
Lordship.
can you by a cabinet decision followed by notification, transfer your responsibilities on a company?
No, Lordship, it is
That is the only
2020 Act, the Indian Vessel Act is very clear, my lord, 5(3).
Of C53,
Yes, my lord.
Designated authority.
designated authorities.
Yes.
But still the inlet waterway is a competent authority.
What is the definition of a designated authority?
Yeah. Lordship. Yes, Lordship, it's N.
Section 2N.
You read
2N.
5(3) and you read 5(4) also.
Lordship, first, Lordship, the designated authority. 2N, Lordship had got it, my lord.
Yes.
Designated authority means the authority is appointed by the state government under subsection 3 of section 5. So we have appointed the officers, Lordship, the government officers for the company. These are the designated authority.
Competent authority.
You read 5(3), 5(4).
5(4), 5(4), and
Heard Mr. A. Dasgupta, Learned Senior Counsel, assisted by Mr. S. Tokovadi. For the petitioners. This petition is filed by the union, so-and-so union, putting a challenge to the order passed by the Commissioner and Secretary dated 16/1/2026 and 12/1/2026, whereby where are the impugned orders?
It's page, Lordship, 25. Annexure A of the writ petition.
Whereby the assets and infrastructure of the Inland Water Transport Department has been transferred and vested on the on whom it has been transferred? Assam Inland Waterways Company.
Company limited.
Company limited.
So, Learned Senior Counsel submits that this cannot be done by way of an executive order, and the same is violative of the provisions of Article 154 of the Constitution of India, 1542 of the Constitution of India. As per the information available, no such statute legislation has been enacted by the state for transfer of these assets and fixed and floating assets under the department scope. The Learned Counsel has also referred to a judgment of the coordinate bench where the challenge previously was made, and this court had allowed the writ petition voting specifically that for transferring the responsibilities of a department, the same has to be backed by legislation and not merely by means of an executive order. So, under such circumstances, the writ petition has been filed. At this stage, the Learned State Counsel, MS M.D. Bora, submits that she is not posted with the required instructions and would like to place the same before the court. Considering the issues involved, issue notice returnable 4 weeks. The respondents are represented by MS M.D. Bora.
Lordship, my friend is appearing.
Therefore, notices are waived. Extra copies be furnished within a period of 1 week. The steps on respondent 4 by speed post
within 1 week from today. Issue notice on the interim prayer. Also, list again on 11th of March.
Lordship, my lord, deeply obliged.
Notice on interim prayer. Notice on interim prayer.
Lordship.
Notice has been issued. What interim orders do you want?
In fact, Lordship, may I submit one thing?
Interim order. What interim prayers do you want? Have you prayed for?
Yes, ma'am. 16/1/26 order. Annexure A.
16-1 is at page 25.
Lordship. My lord, may not pass any interim order, Lordship, I will file affidavit because their union has already challenged the rules. This division bench has already dismissed their case. After the Sanstha came before this honorable court, my lord has
No,
disposed of
what has been challenged before division bench?
the rule, 2018 rules.
No, 18 will define.
And this has been dismissed by this honorable court. And
Regulated.
these pleadings, Lordship, if in a technical ground, this also this petition is not maintainable, my lord. If Lordship may allow me to submit, my lord, the petitioner is represented by the secretary, but name is not there. Union secretary, it's okay, 67 years old, this can be accepted. But where they have pleaded that he has been directed, he has been asked to file this writ petition on behalf of the union, nothing has been pleaded in the writ petition because the union is before my lord. Once they filed a writ petition as a sanstha, another writ petition as a union, but nothing is pleaded in the writ petition. Where is the meeting? They have minus annex that he has been directed to file this writ petition before this honorable court. Lordship, I will file affidavit, my lord.
Let there be a hearing on the
Lordship.
interim prayer. Because staying this will not give you, will lead to further confusion.
Next that, my lord, may, I'm so deeply obliged, Lordship.
Issue notice on interim.
Yes, we have done it. But then we should return
Deeply
it on
obliged.
11th of February.
Lordship, is on 11th of March.
11th of March.
Deeply obliged, Lordship.
Yes.
Wait, please, my lord. My lord, petitioner's husband was an LDO in the office of the CEO of Hailakandi Zilla Parishad. And he expired while in service in 2012. He served from 1988 to 2012. And thereafter, pension was paid to the petitioner.
There is already an earlier order.
There is already an earlier order. That's true. So now we have got the money also. So now whatever prayer at this stage is, because of the delayed payment, because the arrear was from 2006 to 2012, arrear for non-payment.
You should have made a prayer in the earlier writ petition.
Actually, Lordship, how the earlier writ petition ended was that there was no affidavit from the side of PNRD.
Whatever it may be, your prayer was for release of the arrear.
Was for the arrear.
The arrear, there's a direction for releasing it.
Yes.
That area was released.
It was.
Now, once you have received the amount, now you want an interest on that. When you could have very well made a prayer before the court that the payment along with interest should be released.
That could have been done. Lordship.
Could have been done. Should have been done.
Should have been done.
Not done. Why should we entertain this petition now? On what ground?
So, Lordship, what had happened is that at that stage,
whatever may have happened has happened. Once the matter is ended, why are we now digging up this issue and asking for an interest now? There is this principle of constructive res judicata will apply here. You should have pleaded this, you did not plead it.
That is something, Lordship, that.
So we dismiss it. Unless you want to withdraw it.
Lordship, whether it can be left to the authorities to take a considered view on this, at least that much, if not a mandamus. I cannot ask for that much, maybe may not be a mandamus.
Third Learned Counsel for Parties, this writ petition is filed by the petitioner, praying for a direction to the respondents to pay an interest of rupees, the interest at the rate of 10% per annum against the area salary payable to the petitioner's husband and which subsequently under orders of the court was released. So petitioner had earlier approached this court by filing WPC 3178 of petition, which came to be disposed of by order dated 13/12/2023, directing with the following direction. Page number 12, second paragraph. After the writ petition was disposed of, the petitioner, the respondents had released the amount. So, subsequently, the petitioner has approached the authority by filing a representation praying for grant of interest at the rate of 10% per annum. The said prayer not being granted, the writ petition has been filed. Although CPC is not specifically applicable, spirit of CPC is applicable. And on the principles of constructive res judicata, the petitioner ought to have made prayers for release of interest, if any, at the time when the earlier proceedings was filed, which came to be disposed of by order dated change. Under such circumstances, at this stage, the court, there are no explanations furnished in the writ petition as to why his prayer was not made or could not be made by the petitioner at the time when the writ petition was filed or disposed of. So the area salary for the petitioner's due to the petitioner's husband was released by the petitioner pursuant to the orders passed by the court, ID order dated so and so. So under such circumstances, we find no merit in the writ petition. However, since the representation has already been filed by the petitioner before the respondent authorities, we permit the respondent authorities to pass appropriate orders on the same representation within a period of 4 weeks from today.
Much
At this stage, in view of the order passed today, without issuing notice, writ petition stands disposed of in terms of the direction. Mr. Ghosh. AK Ghosh appears for the PNR department. Disposed. Yes.
May it please, my lord. My lord, we are challenging the appointment of respondent number 8 and 9, my lord. Respondent number 8 is currently serving as the Anganwadi worker at Pengbari Hati Dipu Anganwadi
What is the
Center.
ground for your challenge?
My lord, we have challenged the result, my lord, which is at Annexure 2, whereby the respondent number 8 and 9 were selected at, my lord, selected as Anganwadi worker and Anganwadi helper. My lord.
No, the question is, why are you challenging it?
My lord, because they had submitted forged documents to get hold of the said post. My lord, forged documents also have appended in my writ petition, my lord. My lord, may kindly have page 41, my lord. This is the mark sheet submitted by the respondent number 8, my lord. Srimati Deepa Boro.
Where is the name of respondent 9?
9, my lord. 9, which part, my lord? The certificate, my lord?
No, in the list.
List, my lord. My lord would have page 31, my lord. 31, my lord. Annexure 2, my lord. 31, last name, my lord. Maina Nayak.
All right, Mr. Counsel, Learned Counsel for the petitioner, PR Salman, and Mr. H. Chakraborty for
Respondent 1, 2, 5.
1,
2, and 5.
5.
Hello, I am appearing for respondent number 10.
Mr.
PK Raj.
PK Roy for respondent 10. MS and Chaudhary for
7.
3, 4, and 7. 3,
Six.
4, 6, and 7. Rules for child development. Mr. Chakraborty, you appear accept notice?
Respondent 1, 2, and 5 lordship.
1, 2, and 5.
5 lordship.
Yes.
Therefore,
notices only state respondents are waived as they are represented by the council. However, extra copies be furnished within a period of 1 month from today. Steps on respondent number 9, 8, and 9. Eight and 9. By registered post within 1 week from today. List the matter after reasonable date on 16th. Meanwhile, they are appointed.
Yeah, appointed.
The appointment of respondent 8 and 9 will be subject to the outcome of the petition. Yes.
I'm deeply obliged.
21.
Make is a lordship. Lordship, the petitioner is an Havildar in the Assam police, but while in service, an NI proceeding was instituted against him, and ultimately, as he was not able to pay the amount, he had to undergo a conviction of 1 year.
He is terminated.
He is terminated. That impugn order is your
Any
lordship.
appeal file?
Yes, lordship.
Departmental appeal?
Departmental inquiry is not done in view of Article 311 as well as Rule 10 of the Assam Service Discipline and Appeal Rules. So in view of that, departmental proceeding was not done. However, I am aggrieved by your lordship may see page 22, the impugn order starts.
Have you filed an appeal?
No, I have not filed an appeal, but I am aggrieved by the observation that I am not entitled for any pensionary dues. Your lordship may find that at 22A. 22, the order starts.
But the question is, there is a statutory forum.
Yes. Yeah.
For filing an appeal. Why have you not gone? Why should that alternative remedy not be known? There must be a ground, you know the parameters.
Because if it is a violation of statutory rules, then I can also approach because there is no reason in the orders. Yes, your lordship is correct, I can go there, but there is no reason recorded for non-granting of my pensions. At page 22A, last part.
Yes, respondents.
Lordship, he may go for revision also or appeal also.
Revision.
Yes. Yes, 63.
63, lordship.
Under?
Assam Service Pension Rule, lordship, for a pension. It is entitled pension, whether it is entitled pension or not. Yes.
It's 63.
Yes, lordship.
A.
63. A and B also.
63. Appeal revision. It will continue. It will directly. 69 rule, lordship.
60?
Page 63, lordship.
No.
Sorry, rule 63, sorry.
Rule 63 is where is reinstated in service.
That is not a
Government servant who is dismissed, removed, or compulsory retirement from the public service, but is reinstated on appeal or revision, is entitled to continue his past service. Now, the period of break service between this, lordship.
How is this applicable in the first place?
Lordship, then they may go for appeal.
Third, learned counsel for parties issue notice returnable 4 weeks. Mr. J.K. Goswami, learned additional senior government advocate, accepts notice on behalf of respondent number 1, 4, 5, 6, 7. Mr. R.K. Talukdar for respondent number 3. Who's for finance?
Finance.
Mr. B. Gogoi, additional AG. Or Mr. H. Aliha, standing counsel, will appear for respondents number 2 and 8. Since the respondents are represented, notices are waived, extra copies be furnished within a period of 1 week from today. Respondents may complete their pleadings, may complete their instructions and file necessary affidavit. List again after the returnable date. Mm. 16th of March.
Of last.
May I please, Your Lordship? This matter relating to compassionate assignment. Like in terms of order of this honorable court in earlier round of litigation, my case was placed before the DLC and DLC has recommended Your Lordship will find at page 24.
Well, so was the order of the court?
Court Lordship, that is page 21.
21. Yes. 21. It was placed then?
Yes, Lordship, page 24
Hmm.
and recommended my name.
Recommended.
Yes, page
Then?
24, 26 is relevant, Lordship.
Hmm.
But the SLC is not considering because of the Lordship OM, another OM passed that is page 32.
I don't know, 26 is they have decided to recommend.
Well,
You're reading from page 26.
page 26. We start from Lordship, page 20.
What are you referring to? Which page?
Page 26.
Yes. 26 is the conclusion of the DLC to recommend.
DLC recommendation.
They have recommended.
Yes.
Yes, then?
Thereafter, Lordship, because of the OM, that is Your Lordship will find page 32. There, Lordship, the SLC is not considering the case. But the similar circumstances, Lordship, this honorable court has already passed some order. That is Lordship page 34. Exactly on similar cases, Lordship. The Lordship may dispose of in and for consideration by the SLC. Lordship.
Yes, what do you say?
No, Lordship,
Third counsel for parties.
Lordship hearing.
The learned government advocate will obtain instructions
Lordship.
on the as to whether the writ petition, present writ petition can also be disposed of in terms of the order dated 10/12/2025 passed in WPC 7034 of 2025 within bracket annexure 5 to the writ petition. List this matter on 16th.
16.
Although notices are not issued, extra copies be furnished within a period of 2 working days. February.
Yeah, please, your lord. But in this case, the actual date of birth of the present petitioner is 27/7/2022. And that is recorded in his birth certificate as well as in other documents. But inadvertently in his SSLC admit card, his date of birth has been recorded as 27/1/2002. And subsequently, he has joined in the ITBF, Indo-Tibet Border Police Force in the year 2024. And during his preliminary stage, lordship, recruitment process, the matter has been raised before the authority, and he has cleared it by submitting an affidavit as well as other documents also. But subsequently, during the revised scrutiny, lordship, he was removed from his service, lordship. I order dated 23rd/8/2025.
He was already appointed.
Yes, lordship. He was already appointed and he was posted. But some
Have you filed any appeals?
lordship,
Departmental appeal.
departmental appeal.
Have you filed?
Fine, lordship.
What happened?
No, they have not considered my so-called reply, and subsequently by an order dated 23rd/8/2025, I have been removed from my service. Lordship. This is an XRH, lordship.
Will issue notice here.
Yes, Lordship. And page number 34, 35, not here, Lordship.
Huh?
Page number, some pages are missing, Lordship.
Where?
Page number 34 and 35. And appointment letter also not annexed, Lordship.
Where is the appointment letter?
Although, lordship, there is no
Required,
appointment letter, in the order, it is clearly reflected that he has been posted and he has been working.
What do you mean there is no appointment order?
No, lordship, appointment letter is there, but it was not annexed, lordship. I will annex it.
You bring it. Then
Okay.
after that, we'll issue notice. Heard counsel for parties. Petitioner is aggrieved by the order of dismissal from service, removal from service due to mismatch in the date of birth, which was furnished by the petitioner during the process of selection. Stop. Being aggrieved, it is submitted that the petitioner preferred departmental appeal, which also came to be rejected. And accordingly, he has approached his court praying for direction, for setting aside with his order of removal from service. Stop. During the course of the hearing, on being pointed out by the learned CGC, that the order of appointment is not enclosed to the writ petition, the counsel for the petitioner submits that the same shall be brought on record by way of an additional affidavit. He prays for how much time?
15 days, lordship.
2 weeks time to bring it on record. Accordingly, lists this matter again on 27th of February, by which date the additional affidavit containing the appointment order shall be brought on record by the petitioner.
Deeply obliged.
MS, this was for the respondent.
Your Lordship, the engaged counsel is appearing in another courtroom. Kindly pass over the matter for kindly.
Pass over to the time being.
May I please, Lordship, my lord, the petitioner has to retire from service on February 2027. Meanwhile, a common transfer has been placed by annexure A, page 15, my. Is a common annexure, my lord. Sorry, madam. By page
D, 21.
D.
Page
21.
21.
21.
Okay.
Is a common transfer order, my lord. Now, your lordship will find the incumbent at serial number 1, Sri Abdul Kedar, the office which he has been posted by transfer, that is office of the Deputy Director of Economics and Statistics, where I am working. I will be retired by 2027 February. Today is also February and
We are
next,
just entering 26.
my lord, no, next 27 I will be retired. My lord, now your lordship will find.
Is there any circular? That
My-
2 years,
Before, not circular, before retirement, one should not be disturbed.
under what provision of rule, regulation, circular, precedents?
But circular, the some Supreme Court decisions are there.
So you get those some decisions, we will go through it,
My lord,
pass appropriate orders.
the thing is that since he has been posted there,
Hmm.
so I have been, my lord, transferred, that is by Annexure E, page 23. By subsequent order, my lord. The second part, in the interest of public service and for the smooth functioning of official work, Sri Ajit Kumar Borgorari, Senior Assistant Officer Borpeta is hereby transferred and posted to Deputy Director Reconciliation Dorong, my lord. There here in this place, I have been posted just in February 24.
Which place?
That is your lordship, page 15, Annexure 1. Page 15. There also I have not completed 3 years of service. Man. Subject to reversion without any reason thereof. Following junior assistant district establishment under directorate of so and so, so and so, so and so, so and so.
You are sent to Borpeta.
Yes. Now I have been transferred by this order in the on January 24 at Borpeta. But here I have not completed even 3 years now. Just 2 years completed. Now next year I will be retired, man. And in the meantime, that's I have already some settled down there at Borpeta. My son is also going to appear matric exam from tomorrow. Exam will be commenced by tomorrow. Admit that I have. So even my wife is also ailing, man. Day-to-day suffering, day-to-day medical checkups are there. In this circumstance, I pray, my lord. Because
Where were you transferred?
To Dorong.
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 Dorong is a good place. There is medical college everywhere.
No, but I have with family, man, I have gone there. I have gone with family, man. Just 2 years completed, and again I have interest. But the
Only
next year I will be
138
retired.
kilometers from Borpeta to Dorong, Lords.
Yeah?
138 kilometers only, Lords. 3.5 hours, Lords.
Mr.
And private respondents also there, Lordship. In the interest of justice, Lordship.
Private respondent not yet joined because
Not
there is
state, Lordship. I obtained instruction whether he has joined the new place, Lordship.
no.
The order was
No
issued
order
on
has been mentioned
31st,
there.
31/26, Lordship.
Within what
I
they
obtained
are
that
to
instruction,
join.
Lordship, whether he has joined that new place or not, Lordship.
Get instruction.
Lordship.
Get it by 2 o'clock.
Also, tomorrow, Lordship.
Right?
Tomorrow, Lordship. We'll obtain answer tomorrow, Lordship.
Tomorrow already.
Tomorrow, Lordship.
Let it be tomorrow.
Tomorrow, Lordship.
Obliged.
Obliged.
Maybe Petitioner participated in the recruitment of Constable GD, my lord, but she was declared unfit in the by the Review Medical Board as well as Medical Board. Your lordship will find case 50 is the, my lord, Review Medical Board. And 51 is the original. On 2 grounds, my lord.
Order to this. Similar court, similar order has been passed by coordinate branch lordship in this similar issue, on this similar issue.
This order.
Yes, lordship.
But I have already filed a representation, my lord.
You go through the order. 2 o'clock. 2 p.m. You go through the order. Tell us.
Another item is there.
Huh?
Another item is there. Yes, my lord. In this case, my lord, in the same recruitment, my lord, petitioner got the cutoff mark, but he was not included in the final select list, my lord. I have stated, my lord.
Yes, instructions.
Yes, notice.
Non-creamy layer, obviously.
Non-creamy layer certificate, lordship, OBC certificate.
I have the certificate, my lord, on the cutoff date.
Notice may be
Was
go,
it submitted?
Submitted, my lord.
notice may be go, Lordship.
Well, I heard learned counsel for the parties issue notice return about 4 weeks. MSS Bhagwal and CGC appears on behalf of all the respondents. Therefore, notices are waived, extra copies we furnish within a week. No, sorry. Respondents 1, 2, 3, 4, 5, 6. And who's for the state? You can. MS so-and-so appears for respondent number 7. Since the respondents are represented, notices are waived, extra copies we furnish within a period of 1 week from today. List again. After the returnable dates. 20 March 20.
Some interim.
Already
What interim?
result is declared.
Right.
Lordship. Of license.
51.
That's if DNAT will appear in this matter. This
Huh?
will be taken after some time. That's
Who?
DNAT.
DNAT.
Yes, Lordship. Senior Government Advocate.
Oh, this is that same matter.
Yes, Lordship.
So we have fixed the matter on 16th.
Yes, Lordship. Monday.
16th. The addition, the Advocate General was there. He prayed that some instructions be granted. So we have kept that other matter on 16th. So both these matters we can take it up.
Well, I have a little submission. So far, I am told that the only the similarity in respect of the other petitions with this is that challenge relates to the appointment of PP, additional PP and extension. I do not know whether the points they have taken are similar with my petition. I am told that those points have not been ventilated before this honorable court. Here, what happened, my lord, lordship, kindly see, I would like to apprise the position. Way back in January 2024, advertisement was floated for appointment of 299 posts of in total of PP, additional PP and assistant PP. And the process of selection is only by way of reviews, interview. Kindly consider.
And proficiency?
Sorry?
Proficiency test or something?
Proficiency test, nothing. Only Baibabusi. No other test.
What test do you conceive of?
Well, there ought to have been some test proficiency. Lots of people kindly appreciate. Courts have held time and again that interview, Baibabusi test is not the absolute factor to judge.
But you participated.
I participated. I participated. To that extent, I am not
questioning the process. Then you should have challenged the advertisement.
No. Well, my point is not that. What I mean to say is, at any rate, ultimately, the interview board has submitted a list, select list, showing the merit position with the marks secured by them. Was it not fair on the part of the department to publish it?
Publish what?
Publish that list. These are the selected candidates.
The select list is published, I think.
No. That is
Select
my
list not
case.
published.
No, my lord. No select list has been published.
He said it is published.
But kindly see, my lord. Let me
In fact, in
complete.
the other matter, the select list was challenged.
Select list here is also one, but it's not the select list. This is a provisional list.
What was
Final
provisional
select list has to come. But what happened here? That is why I am agreed. We, authority, to our knowledge, the board submitted a select list of 295 candidates.
299.
299 candidate selection was, the list was submitted. And thereupon, the authority has asked for the police verification report in respect of all this. Lordship will kindly appreciate, they now go on applying that FRBM Act, that one post, against one post, only one selection, not more. Earlier, the system was different. There's a panel of list, waiting list and all that. If somebody doesn't turn up from the final select list, then that list in the waiting list will be taken care of. Here, only 1:1 selection. 1:1 selection, therefore 299 candidates were selected by the board and that list was forwarded. And in respect of those persons, police verification report was asked for. We were asked to appear before the police. We appeared and verification report has been submitted. So obviously, then therefore, we were selected. Report was submitted. And thereafter, but then that list has not been finally published. Now the authority has come up.
How many candidates appeared against
Some,
299?
huh?
95.
295? How many candidates appeared?
295 for this police verification, but there was overlapping of 50.
295 candidates appeared for police verification. That
Against
is
how many
overlapping.
posts? Against how many posts?
299 post.
299 posts.
299. Okay.
299 posts, 295 candidates appeared for police verification.
Including the petitioners.
Yes.
Including the petitioners. And they have been cleared. Finally now, because there are some overlappings in the sense that same candidate have applied for PP, additional PP, STPF. They say that if someone is selected, unless he opt for, he will be given the top post. That is the advertisement, they say. Now they have come up. They have come up with a list of 241 candidates and declaration is made. That is provisional list that they will be appointed on 11th and 12th over telephone. Candidates have been asked to come to take the appointment letters. We have been excluded.
Rest of the posts.
No, we have been excluded. That is my grievance. Why I say, Madam, that otherwise also, only on the basis of interview, it may not be very fair.
But that,
And when
but that they may not be available for you because you had already accepted, appeared.
Yeah. Only what my question is,
Hmm.
to word of any kind of apprehension that there is nothing wrong and the selection was fair and all, the authority was bound, duty bound to publish that select list, which was submitted by the board, selection board. Why that has not been done? That ought to have been done, then it would have been legitimate
without the
expectation
select
is there.
Without the select list being published, how do you know that 241 candidates have been informed or selected or?
Yes, my lord. Kindly see two provisional select lists they have published. 138.
138.
Yes, Annexure 5. What it says, kindly see. As recommended by the selection boards constituted by the state government, Vidal, so-and-so, dated 26/2024. The following candidates are provisionally selected for recruitment to the post indicated below. They are provisionally selected. Is a provisional select list. And then it goes on, next few pages. Here, kindly see 295, 181 serial number. Here there are overlappings. Where there are overlappings, because out of that 294, 53 overlappings are there.
Overlappings means?
Overlappings means one person applying in 2-3 posts.
So they'll have to make a choice.
Yes, they will have to make a choice. Authority says in the advertisement itself that if they do not give their choices, they will be.
So how many persons have made this overlappings?
53. 53 overlappings are there.
53.
53. So, kindly see page 146. We have prepared that list. Going from the list they have published. Annexure 6. One person has applied number 1, number 2, he has applied in 2 posts. But then 1, number 5 has applied in 3 posts. Number 6 has applied in 2 posts. This is how these overlappings are there. Next page, total overlapping comes to 53.
What about
And-
the other posts?
Sorry?
What about the other posts which are yet to be filled up?
They have not said anything. They have not said anything.
Therefore, my grievance is they are going to make appointments.
Hmm.
We have been, in our case, police verification is done. All that is
How
done.
many writ petitions?
We are 19 here. Huh? 12, sorry, 12. 12. Therefore, my responsible submission is, if they go ahead with the appointments of the act, I will definitely pray that no appointment should be made unless they produce everything before this honorable court, how the things have moved. And you see, January 2024, we are in February 2026. All this more than 2 years, the process has not been completed. Suddenly they have geared up everything overnight to appoint. Lordship can understand what I want to mean. That should not be. That is just the doubt.
I don't understand anything unless you submit before the court.
That harshness.
Else whatever you submit must be supported by your pleading.
Well, that harshness itself suggests cast a doubt on the mind of the people.
But that argument would be self-defeating.
Well, no.
On one hand, you are saying for 2 years they have not done anything.
Yes.
And when they expedite the process, you say
Expedite the
they are
process.
expediting.
Rightly, Lordship has asked me the question. But then expediting means going through publishing the merit list, then one by one, and go for appointment.
So let them
That is not been done.
here.
Therefore, if they want to say that they may have instruction, all that, Lordship will kindly protect my interest. At least this 12 petitioners, 12 posts should be kept.
Your interest will be protected by saying that the appointments, if any made, will be subject to the outcome of the writ petition.
Well, that of course is there. That will as a general protection. But so far the petitioners are
Because
concerned.
what has happened is, you are the second petitioner. We don't know how many petitioners were there in the earlier one. I'm sorry, we forgot.
But in earlier case, 4 petitions are there.
4 petitioners.
4 petitions.
So now there are 16 aggrieved parties before the court.
Yes.
There is a possibility that more people may come.
Maybe.
Then for every case, if we have to reserve the post, how will the appointments be made?
No, my lord, Lordship will kindly appreciate.
So therefore, your
interest
will be protected,
my lord, Lordship will
making
consider,
it subject to the outcome.
my lord, Lordship will consider every case on their own merit.
But certainly,
Therefore, if your Lordship finds that there may be one and more petitions, then Lordship will consider it accordingly.
that's beside the point. What we want to say is, as on date, from whatever you have submitted, there appears to be some posts still not filled up.
Yes.
Number one.
Therefore,
there is a possibility that your names may be included in those posts which are yet to be filled up. Number two, there is a case of overlapping. So one person has applied for 3 posts. So only one is to be selected. So these 2 posts will again have to be either re-advertised or filled up by the other
right, exactly.
candidates.
Yes.
And in case we find that no, the selection finally is contrary to law, then we may have to set aside.
Yes.
Or specifically, if we have to take up that these cases need to be interfered with,
Yes.
then if it is interfered, then
there will be vacancies.
Vacancies available. Your cases will be either considered or freshly advertised.
Well,
But not filling up the post, is these other candidates, their names appear in the select list, right, wrong, it is appearing in some list, police verification done. This post will be filled up to augment the prosecution team before the various courts. So if these posts are vacant,
these posts are vacant or not, in fact.
If these posts are not allowed to be filled up, then there is a possibility of...
Obviously, they are going ahead with 241. They are going ahead with appointment of 241. And I am told, my instruction is that posts as such are not suffering from the want of prosecutors. They are all there. They are in contract basis. Government has given them. They are all working.
But whatever, the
But
state
now, my Lordship will appreciate things have changed. Now it is an appointment. Till the other day,
we had the PPs, additional PPs, they are all as the advocates appointed by the clients. Now, they will be the employees of the government. This is the difference. They will have a permanent post, permanent appointment, and they will continue.
Well, in fact, challenging the entire process, some petition has been filed and Lordship has issued notice in that case. I have given the order. And Lordship has also observed that the appointments made will be subject to outcome of the petition, the last page. Well, here in this case, in fact, we have wait for some time to have our instruction. Along with the other matter, kindly take it on Monday.
Well, my difference is only in other two cases, those people are not selected. In their case, probably verification was done.
It was done.
In
That's
my
the
case, it
submission
is done.
subject to correction,
Yes,
as far as I recollect.
Yes, in the other case also.
If you want, we'll issue notice up to you, whatever you want to say. Or we can take it up on 16th as prayed for.
Yes.
16th Lordship will take up, but
All right.
meanwhile Lordship will protect my interest. That is my prayer. Because here we
Your
apprehend,
protection will be subject to outcome of the writ petition.
Lordship will accord it. Because
No, but then we'll have to issue notice. Without issuing notice,
no, let there be notice, let them respond to it.
then
Indeed,
if we issue notice, why fix it on 16th?
because other matters are pending.
The
That is
matters
what they
are
say.
different.
And
If we take up this matter on 16, there is another matter. So notice or otherwise, whatever we have to
in
issue.
other matters also Lordship has issued notice. So they will have to.
No. Only one matter had
Today,
come and
Lordship, in
that is
item
deferred
16.
to 16.
Oh, Lordship has not issued, but the other matter it was issued, I am told. Therefore, what I mean to say is one step further. Notice means they will respond officially before this honorable court. Things will come before this honorable court. It will facilitate consideration. That is why I am saying. Notice.
Came also learned senior counsel assisted by Ms. So-and-so, learned counsel to petitioners. And Mr. D. Nath, learned senior government advocate appearing for the respondents. 1, 2, 3, 4,
1 to 5.
5. Therefore, notices on respondent 1 to 5 are waived. Extra copies, however, will be furnished within a period of 1 week from today. Steps on respondent 6 to
6 to
46. Must be undertaken by registered post. Speed post.
246.
Well, may I say here, by email, we may send notice.
You take registered post and email whatever, because the official, the standard procedure has to be ordered. Na?
Lordship will order.
We'll permit you to take by email also.
Email.
Registered post within 2 weeks from today. At the request made by the learned senior counsel, permission is also granted by this court to undertake service of the writ petitions on the private respondents by way of their respective emails. So the petitioners are all practicing advocates who had responded to the advertisement dated so-and-so, issued for filling up posts of public prosecutor, additional public prosecutor, and assistant public prosecutor in different courts across the state. That is not for high court.
No.
Only for trial courts.
Yes,
Only for trial court.
for trial.
The petitioners submit that they had all appeared for the Viva Voci, which was the only mode for selection of the candidates, and had also subjected themselves to this verification. So however, the authorities have published a list of how many? 241.
Sorry?
How many candidates?
1 is to 1. So total candidates,
How
241.
many in the list? How many candidates?
241.
241. 241 list.
So
Where is
for
that list?
document verification, they were asked.
Where is that? Where is that list?
170.
170.
138.
Oh, sorry. Huh?
Page 138.
Huh?
Page 138. It starts at page 138. And
138.
NHF 5.
138. In terms of the recommendation of the selection board constituted by the state government, the candidates mentioned in the said notice were provisionally selected for recruitment to the posts as indicated below. Stop. The petitioners are aggrieved that their names do not figure in the said list. Stop. That apart. In terms of the advertisement, the vacancy notified was 295.
299 vacancies.
299
Total.
vacancies. There is no information from the respondents as to what has happened to the selection process in respect of the other vacant posts as per the advertisement. Stop. The the learned senior counsel has also submitted that there are many candidates who had applied for all the three posts, namely the posts of PP, additional PP, and assistant PP. But appointment is to be made to only one post. So therefore, the other posts to which such candidates had also applied for will have to be filled up. Stop. It is therefore submitted that no information has been issued by the department as to why the petitioners were not considered for appointment. Stop. There was no written test, only viva, and thereafter police verification. Stop. To the best of the knowledge of the petitioners, there is no deficiency for which they could not have been appointed. Stop. Being agreed, the present writ petition has been filed. Mr. D. Nath, appearing for the state, submits that he would like to complete his instructions in the matter. Considering the issues raised, at this stage, notice the issue, returnable 4 weeks. Respondents will attempt to complete their instructions and file necessary affidavits. Interim prayer, although raised by the petitioner, at this stage the court is of the view that notice be issued on the interim prayer, making it returnable on.
The other case is fixed on 5th of May, madam. The order I have given.
5th of May.
May, madam.
May.
May, madam.
Why? So long?
Court has given.
Next on 13th of March. It is made clear that any appointment made
Respondents are there, madam.
to the writ petitioners shall be subject to the outcome of the present writ petition, subject to the orders passed in the outcome of the writ petition.
He was given the March date. Date is March.
March 13th.
13th.
Yes.
Apply.
Okay, logic. Oh, problem.
Lordship, in this case, before my friend starts Lordship, there is one lacuna in this case. The impugned order has been passed by the Commandant 38th Battalion, who has not been implemented. Every steps has been, he is a Jawan of 38th Battalion, who are not a party. Let him file a petition seeking implement of him. Otherwise, records will not come.
We'll file. Counsel for the learned CGC has raised an objection that the petitioner it is a case of dismissal.
Lordship.
Was an employee, was serving under the
38th Battalion,
38th,
BSF.
38th Battalion of the BSF.
BSF.
However, the commandant who has issued the impugned order has not been arrayed as a party. Rather, the commandant of 170 battalion has been arrayed as a party who was not the
It has
authority
nothing to do, Lordship.
who is not connected with the present
Only the proceeding was held there.
proceedings. Stop. Para, the learned counsel for the petitioner seeks liberty of the court to file necessary application for implement of the commandant of 38th Battalion. He prays for 2 weeks?
2 weeks time.
2 weeks time. List again. After 2 weeks on 20.
Battalion, disseminate process.
Sorry, on 27th February.
Okay.
None appears for the parties on roll fast over for the day. Yes. Have you implemented?
Lordship, implemented Lordship, but no formal notice was issued, Lordship. So, respondent number 6, Lordship.
Respondent 6.
Respondent 6, newly implemented
Accountant General.
accounting general.
Pursuant to the orders passed by the court, the petitioner has taken steps to implement the Accountant General A&E Assam Pension Branch, Moidamgaon, and amended course title to that effect has been filed, whereby the said respondent is added as respondent number 6. Stop. That I issue notice, returnable 4 weeks. Steps be taken on respondent 6 through any of the learned standing councils representing the Accountant General. Matter be therefore listed on 27th of February. MSS Burwa appears for all the other respondents.
1 to 4.
1 to 4. Mr. A. Cholia for respondent number 5. A finance or even Matira Koksu? Finance. Yes.
May I please? This is the IA for correction of the course title, my lord. Page number 60, my lord.
Who's for the respondent?
Page number 60.
Who's
It is
for the respondent?
ETC, my lord.
Yes, page 60.
Page 60, yes, my lord. Petition number 81, Rajiv Bosumutari, son of Rotan Bosumutari, Amguri, and same, my lord, page number 63. Petition number
Page number
60.
60.
60.
Okay.
Petitioner number 81.
81.
Yes, my lord.
What has happened to him?
Rajiv Bosumutari, son of Rotan Bosumutari, village Amguri, Pio Amguri, the address, same page number 63, petitioner number 99, both the address are same. It should be page 63,
Well,
petitioner number 99. What the name of the
they
petitioner?
are two different persons.
No, same petitioner, my lord. Only the address and the further names are recorded same. My lord. The correct one is page number 42, 42, my lord. In my application. Paragraph number 6, page number 42. Only address and the name of the father are same.
Heard. Hey, yes, who's for the respondent? Any objections?
Objections.
Heard. Mr. A. Boro, learned counsel for the petitioners, and then so and so appearing for petition by order dated 31/10/2025, passed in WPC so and so. The writ petition stood disposed of in directing the respondents to grant the benefit of minimum scale of pay to the petitioners in terms of the decision rendered by the division bench of this court in Upen Das, reported in 2020 so and so, page number 74. Stop. The learned counsel for the petitioner has now filed an IA to submit that the name of the petitioner at serial number 81 of the writ petition, namely Rajiv Bosumotari, as also the person, the petitioner at serial number 99, who is also reflected as Rajiv Bosumotari, is one and the same person.
No, my lord, both are different person.
Different persons.
Yes, ma'am.
Are two different persons, whereas their names, whereas their father's name and addresses are shown to be one and the same. Stop. The correct particulars are reflected in paragraph 6 at page 42 as under to extract Koririba. The learned counsel for the petitioner therefore submits that this error of the petitioner's name at serial number 81 and 99 had occurred due to oversight, an unintentional mistake on the part of the filing counsel. Stop. Therefore, upon the same being noticed, the present application has been filed seeking necessary corrections as per the particulars reflected in para 6 of the present IA. Stop. The learned counsel submits that the names of the petitioners at serial 81 and 99 of the writ petition in WPC so-and-so be corrected as the particulars reflected in para 6 of the present IA. The learned counsel for the respondents.
4 to 18.
4 to
18.
4 to 18.
18. Does not object to the prayer made. In that view of the matter, this IA stands allowed. The name of the petitioner at serial number 1 in WPC number so-and-so, name of the petitioner at serial number 81 and serial number 92, both by the name within quotes Rajiv Bosumotari, will stand corrected in terms of the particulars particulars specified in para 6 of the present IA, which are as under. Para 6 the cause title in WPC number so-and-so accordingly stands corrected to the extent indicated above. Stop. No further corrections are required in the body of the order dated so-and-so passed in WPC so-and-so. Stop. The order passed today in IA so-and-so shall be read together with the order passed in WPC so-and-so, ID order dated so-and-so. This disposes of the IA in terms of the above. Disposed.
Deeply obliged, my lord.
Huh?
Yes.
Yes.
Yes, my lord. Order is given, my lord.
All right. Same order.
Yes, Lord.
Part disposed.
Obliged, my lord.
Obliged.
Get up one day. Yes.
Not a similar issue, my lord, has already been decided by the Honorable Division Bench, my lord.
What is that order? Who's for the state? Health
Department, my lord.
Health department.
Lordship.
Health department. What was decided here?
Lord, the termination order has been set aside, my lord. 81 employees were terminated, my lord. And they approached this on court. And our case was not tagged along with those group, my lord. So.
You wait for a while, let us see. Or let it be listed on Wednesday.
Lordship, it will be better, my lord.
Wednesday. As the counsel for the health department is not available in court. List on Wednesday. Mr. Arali for the petition.
Congratulations.
So on the last occasion on 9/1/26, the written instruction was sought from the director. Why despite recommended by the selection committee, I have not been appointed as Anganwadi worker.
Written instruction is here, Lordship.
Bring it on record.
Lordship,
Bring it on record.
Lordship.
Let him have the benefit.
Written instruction is here, Lordship. Okay.
Mr. S.K. Das, counsel for the appeals for the petitioner, and Matachari, and an additional senior government advocate. It is submitted that instructions have been received from the
Director, Lordship, Assistant Director, Lordship,
from the Department of
Women and Child Development, Lordship.
Child Development. Therefore, she would like to bring it on record.
Lordship.
The prayer made is allowed. List is meter. 27th
27, yes, Lordship.
or in March.
No, Lordship, it can be
27.
27 February, Lordship.
So the interim order may kindly be extended.
Interim order passed earlier. If any, continue till the next week.
Deeply obliged, Lordship.
My pleasure, Lordship. Lordship, we need some time to file a reply affidavit. Lordship.
The petitioner seeks further time to file reply, join the affidavit.
Yes.
Counsel appearing for the petitioner does not object to be prayer made listed again after 3 weeks on 13th of March.
Interim may continue, Lordship.
Interim order passed early, if any will continue till the next date fixed.
Obliged.
Lordship, in this case, we have some time, request some time, Lordship, to file affidavit. Otherwise, he is in protection under.
Mr. As Doctor Counsel for the Revenue,
Lordship.
praise for further time. Complete his instructions and file it. Mr. T.V. Botaku, appears for the writ petition. Prayer made, does not object to the prayer made. There's some interim order.
Yes.
Accordingly, matter be listed on 13th of March.
Published.
Interim order passed earlier, we continue
That's
till the next date fixed.
Deeply obliged, Lordship.
My lord, in this case, last occasion, my lord, to instruction, my lord, for regarding my lord appointment letter, my the petitioner, my in the CRPF.
I have received instruction, Lordship.
You want to bring it on record?
Yes, I'm, Otherwise, SSC should be on party made party here, Lordship.
Who should be?
SSC, Staff Selection Commission.
What is your challenge here?
My lord, petitioner, my lord, initially employee of my lord SSB, my lord, and he was my lord dismissed from service, my lord, on 8/3/2025. My lord, during my lord his service period, my lord, he appeared, my lord, in the my lord SSC exam, my lord, for the CRPF personnel post of my lord sub inspector, my lord. Accordingly, he was qualified, my lord, and an appointment letter was issued, my lord. My lord, what happened in the appointment? Whatever appointment, there was a clause, my lord, for the NOC for the previous employment. So he filed a representation, my lord, to my lord regarding my NOC, my lord. The respondent SSB not issued. So he approached before the honorable court, my lord, file IA, my lord. Kindly see the IA, my lord, page 89, my lord. Order and effort up. In IA, my lord, this honorable court, my lord, they allowed, my lord, issue the conditional, my lord, NOC subject to the outcome of the, my lord, writ petition, my lord, 32323, my lord, which is pending against the dismissal order, my lord. So accordingly, my lord, SSB, my lord, issued the NOC, my lord. From NOC, my lord, we have petitioner no issue, my lord. My lord, now, my lord, what happened, my lord, similarly situated person, since he is already qualified, my lord, sub-inspector post, similarly situated person issued, my lord, the CRPF appointment letter, my lord. Where, my lord, the training period already, my lord, is base by base was going on, my lord. Next period, my lord, training period on 13th February, my lord, 2026. The CRPF, my lord, not allowed me, my lord, to join, my.
Because
that is why, my lord, petitioner filed, my lord, this second writ petition, my lord.
Yes, Lordship, as our instruction received from the CRPF authority, Lordship, they have communicated to SSC, Lordship, Staff Selection Commission, who has issued the select list, Lordship. And as because the case was pending and he was departmental proceeding also pending, therefore CRPF wrote a letter to the SSC to accommodate him in SSB, Lordship. That instruction I have received. And I want to bring this instruction as
So release him so that he can go and join.
appointment letter not even released, Lordship, not issued to the petitioner, Lordship.
Even my marks, my lord, not my lord, in respect of my lord SSB in SI post, my lord. My marks, my lord.
Let her bring it on record then.
My lord, 13/2 is the last day, my lord. That is why, my lord. 13th February, my lord. My lord, kindly see I have annexed, my lord, the training period, my lord. That is page 104, my lord. Already one batch already trained, my lord.
In SSB,
104, my lord.
there was the 8 posts are vacant, Lordship. In
The
SSB,
marks, my lord, I'm not getting, my lord.
No, where is where is it specified that on the basis of marks, the preference will be given?
There is a cutoff mark, my lord, in SSB. My SSB marks is 300, as per my information, my SSB 327. I'm not get, my lord, the SSB equivalent marks, my lord. That is why, my lord, CRPF is my lord, cutoff. My lord, offer of appointment, I kindly see, my lord, page 80, my lord. It was issued, my lord, it was issued on 24th October 2025. By, my lord, the CRPF, my lord.
Page number?
Page, my lord, 80, my lord. It was issued me, my lord, CRPF, my lord. But there was a clause, my lord, page 83, no objection certificate or discharge certificate from previous employer. So that is why, my lord, petitioner approached, my lord, the IA, my lord, filed the earlier petition, my lord. This honorable court, my lord, allowed to conditional issue the conditional NOC to the respondent SSB, my lord. Accordingly, SSB already issued, my lord. And filed, my lord, petitioner representation, my along with this honorable court's order, my lord. So now petitioner, my lord, what happened, my lord, the similarly situated person issued the appointment letter by the CRPF, my lord. That is why, my lord, petitioner approached the producer and of course second time. Second petition. To made a party in the CRPF party. Earlier occasion, petitioner not made by the CRPF.
No, now you are required to join in the CRPF.
Yes, Lord.
Then what has happened? They are not allowing you to
Yes,
join.
Lord.
Why?
That is why, my lord, petitioner approached. My file representation, my lord.
because of pending of the writ petition, Lordship, whereas because SSB
petition?
department, no, other writ petition, departmental proceeding is pending in SSB. Where that outcome is till awaited, Lordship.
SSB,
Start,
you are working in SSB.
SSB, my lord.
Then
My
there are
lord.
some proceedings.
Yes.
Yes.
Departmental proceeding, my lord. The dismissal order on 23. That is challenge. That was challenge, my lord. That is writ petition number 3
What has happened there?
My lord, notice was issued, my lord.
Then
That subject to the outcome of the writ petition, my lord. Conditional NOC was also that, my lord.
you connect this petition along with the other writ petition. Now, how will they allow you to join unless in a matter where you are dismissed from service,
My lord.
the matter is challenged before the court.
Lordship.
Without the outcome, what will be the purpose of allowing you to join?
My lord, subject to the outcome of the writ petition, my lord, earlier writ petition, my lord. That is why, my lord. Till then, my lord, I have to join, my lord. Otherwise, my lord, the
Where is
maybe
that order? In the other writ petition?
other dismissal order, my lord, I have.
Not dismissal. The order passed by the court in the other, in the writ petition where you have challenged the dismissal order.
In IA, my lord, kindly see for a moment, my lord.
IA.
I lordship, page, my lord,
IA is not here.
page 90, my lord, kindly.
IA is not here.
No, my lord, order, IA order, my lord.
IA order.
Lordship. Page 89, it starts from 89, my lord.
89.
Lordship. Paragraph 10, my lord, kindly see.
Yes.
10 and 11, my lord. Then, my lord, the next page, my lord, page 95, kindly see, NOC was issued by the SSB after court order, my I order, my conditional NOC, my lord. Page 95, my lord. Then petitioner, my lord, file representation along with this order, my lord. And now, my lord, a similarly situated persons, my lord, issued on 30 December 2025 in CRPF for the post of assignment.
File contempt or do whatever. Why are you filing another writ petition now? This is an order in the IA.
Earlier occasion, my lord, petitioner not made party CRPF, my lord, because there is a CRPF issued the, my lord.
So the order in the IA allowing you to join in the CRPF conditional was issued against whom? CRPF only. CRPF is a party here.
Here, this case, my lord,
In the IA.
IA not made party, my lord. IA, my lord, in reference, my lord, earlier case, my lord.
So you file another writ petition.
My lord.
The order is already there in the IA. If the concerned respondent is not a party, you take steps to arrange for the party for being arrayed as a party instead of filing another writ petition. Why you file this writ petition? What do you want us to do? Implement the order in the IA? What is the purpose of filing the writ petition? What are your prayers?
Prayer, my lord, to join, my lord. To join the CRPF, my lord.
Your representation is there. 7-1.
Representation 7 on your CRPF.
What have you stated?
The last page, my lord, page 105. Non-issuance of call letter, my lord, to the post of sub inspector in CRPF.
Call letter for what?
Is it, my lord, appointment letter, actually, my lord. The appointment letter, other situated person, my lord, on page.
Is it a call letter or an appointment letter?
It is actually offer of appointment. Kindly see page 98, my lord. The other person, my lord, it is offer of appointment for the post of sub inspector, my lord.
98.
Page 90 of my lord. It was issued, my lord, 30 December 2025. They are also selected, my lord, in CRPF. My lord.
So essentially, your representation is that in terms of the order in the IA, you should be allowed to do.
Lordship.
That not having been done, you have come before the court.
Lordship.
Now, what orders will the court pass? They implement the order in the IA.
Since my lord, this petition, my lord, made party, my lord, in CRPF, my lord. And CRPF, my lord, did the
Then how
authority.
can we issue a direction here? The order you are relying on was passed in an IA, where CRPF was not a party.
That's it.
Now you have filed a writ petition where making CRPF a party.
That's it.
And you want an order from the court that CRPF, please implement the order in the IA. What kind of a direction are you seeking? You are within your rights to take necessary steps to implement the CRPF. Any other prayer you have, we can examine, but that order is already there. We are not an executing court. It's not an executing court. That order passed in the IA has to be executed, implemented.
But my lord, I was selected, my lord, SI post, my lord, say in CRPF, my lord. Only, my lord, my problem is, my lord, the dismissal order, my lord. But my lord, tomorrow, my lord, if my lord earlier petition is allowed, my lord, then my lord, the petitioner lost his, my lord, the opportunity, my lord, because.
Now
he is a
come
my-
to page number
If-
94.
Now then he will be appointed on SSB, Lordship.
Read para 11.
Lordship. Lordship, subject to the outcome of the petition.
No, para 11, 94.
Lordship, accordingly, the respondent authorities are directed to issue conditional NOC to the applicant, which shall be subject to the outcome of the WBC number 3223, 2025 within 2 days from today, so as to enable the applicant to join.
Now, have you received the conditional NOC?
Yes, my lord.
You have received?
Yes, page 95, kindly see, my lord. Page 95. On 19 November 2025, my lord. After communication. From SSB, my lord, the petition, they issued, my lord, NOC, my lord.
If
Though it
that,
was not issued earlier, my lord.
if that earlier petition will be allowed, then he will be appointed in SSB, Lordship. That's why CRPF communicate to the SSC to take steps upon this, Lordship. And then that and no any further communication received from SSC, Lordship. That's why if I
So
would
what-
like
what
to.
steps? What steps are to be taken?
I would like to file this file affidavit, and SSC should be implemented as party, Lordship, in this writ petition. Otherwise, he may
Your
withdraw
writ
this petition.
One first writ petition is with regard to challenging your dismissal.
Lord,
So if the writ petition is allowed, what will be the likely order? Dismissal set aside.
Lordship.
Then you will have to be taken back into service,
Then,
Well-
then constable post, my lord. I was constable.
whatever it may be,
Lordship.
constable post.
But this post, my lord, I have lost.
Huh?
This opportunity I have lost, my lord. If lordship tomorrow is lord, repetition is allowed.
No. Constable where?
SSB, my
SSB.
lordship.
Meanwhile, you had appeared for and you selected in the CRPF.
CRPF, no, my that post, my lord, in CAPF, my lord, Central Armed Police Post,
Ah.
including CRPF, my lord.
Ah.
So for the post of SI, my lord,
So your first appointment was in the SSB.
SSB.
From where you were appointed, the proceedings was there and you were dismissed from service,
Lordship.
which is under challenge.
Yes, lordship.
Now, you want to join where?
CRPF, my lord.
CRPF.
Lordship. As per my marks, my lord, CRPF, not SSB, my lord, in the post of SI.
But how can that be allowed during the pendency of the writ petition?
My lord, subject to the outcome of the writ petition, my lord.
So subject to means while the writ petition is pending, you are working for CRPF.
Lordship.
If the writ petition is allowed,
Lordship.
he'll come back to SSB. Because you are challenging the dismissal order.
Yes, lordship.
If the dismissal order is set aside, you may be reinstated,
Yes, for the post of my constable, my lord.
whatever it may be. So from CRPF inspector, what is that post? Inspector,
Sub inspector. my lord.
sub-inspector. You'll resign and join in the post of constable in SSB.
No, my lord, only my lord, subject to the outcome, till then, my lord. Lordship,
Subject to
I'm-
the outcome would be, outcome can be writ petition allowed, writ petition dismissed. And how can the CRPF now permit you to join in the face of a dismissal order in another service?
That is why, my lord, as per the direction of this, my lord, the SSB issued, my lord, a conditional NOC, my lord.
But I have not understood. See, you were selected, appointed in SSB.
Initially, my lord.
Initially, you worked.
Yes.
Then some proceedings was there. Set aside. You are terminated.
My lord, before dismissal order, my lord, as per the proper, my lord, permission, my lord, my lord, selected or applied, my lord, for the post of SI, my lord.
By way of a different petition, by way of a different recruitment process.
Yes, ma'am.
What is it? One recruitment process or separate recruitment process?
As per petitioner, is a different recruitment process, but in this regard, I have not received anything, Lordship.
Advertisement was issued on 4th March 2024, my lord, and I was dismissed from service March 8/3/2025, my lord. And during my tenure, my lord, I was, my lord, applied.
You get your input from CRPF. 16th.
My lord, 13th February is the, my lord, the
Last date.
next, my lord, the training, my lord, I have a next.
Then get it on 11th. 11th.
11.
Get the details. We want to know
Yes, Lordship.
that whether it is the same recruitment process, different recruitment process.
Different recruitment
Different,
process.
I was
Now, you are not coming up with the facts in a sequence.
my lord, I'm constable, my lord, in the year 2022, I was appointed in SSB.
2022,
my lord.
Ah.
And advertisement was issued on 4th March.
23.
2022, my lord, I was appointed, my lord, in the constable, in the post of my, in the SSB, my lord.
Ah.
Then, my lord, advertisement was issued on 4th March 2024, my lord, for the post of SI, my lord. On due permission, my lord, I was applied, my lord, in the post of SI, my lord, or conducted by the SSC, my lord. Accordingly, I was selected, my lord. An offer of appointment was issued, my lord, by the CRPF, my lord. And there was a clause, my lord. That is why, my lord, petitioner approached before this court, my lord, to file, my lord, the IA, my lord. IA, my lord, allowed, my lord, issued for, my lord, conditional NOC, my lord. So accordingly, SSB issued, my lord, conditional NOC, my lord. Now, my lord, the CRPF, my lord, issued, my lord, the similarly situated to the.
After your appointment in CRPF, after your selection in CRPF,
Lordship.
You were terminated or before selection? From SSB,
Lordship.
when were you terminated?
8/3/2025, my lord.
25.
25.
And when were you selected for CRPF?
Before that, my lord, 20 March 2024, my lord, I was applied, my lord, for the post of SI, my lord. Accordingly, my lord, accordingly, my lord, result was declared, my lord, in the year 2024, my lord. So, my lord, kindly see my offer of appointment, that is the page 84, my lord. From the, my lord, that is page 80, my lord, from issued by the CRPF, my lord.
But once you join in CRPF and your earlier writ petition challenging the partner promotion is allowed, let us say, the termination removal order is set aside, you are bound to be reinstated. Then you'll have to resign from CRPF and come back and join. What kind of?
Then it is, my lord, SI post that was, my lord, constable.
Maybe SI post, but it is
Yes.
conditional NOC.
Lordship.
Once the NOC is withdrawn, you'll have to come back or face another proceeding. You have filed a writ petition. You withdraw the writ petition. But if it is up to the CRPF, because in the face of a dismissal order, whether they will appoint you.
আপুনি best এইটোত include কৰি থওক। সেইটো withdraw কৰিম।
Yes, madam.
Yes, Lordship. I have submitted my instruction, Lordship. As further instruction, I have to take time, Lordship.
Lordship, please 11, my lord. In the meantime, they may clear my.
11.
This, yes, Lordship. But it's the finest.
Obliged.
Obliged.
Or let it be on 12. 12.
Yes, Lordship.
12. And the request made by MS Esboga. That
11 is 11 on 11, Lordship. I will bring this instruction whether recruitment procedure defined on 11, Lordship. I can bring.
Permitting her to obtain further instructions is on 11. Yes. Yes.
May it please your lordship. The notice was issued on the last occasion. They are required to file their affidavit.
Lordship, before my learned starts, Lordship, as per the last order, Lordship, direction was given to the railway authorities to dispose of the application for NOC. And Lordship, by 6th of February, Lordship, now railway has disposed of the NOC by rejecting his prayer, your Lordship.
By?
Rejecting his prayer. So Lordship, and there are some certain circulars are also there, Lordship. I'd like to bring it on record, your Lordship.
What is the issue here?
Well, the issue is that, my lord, the petitioner, he was working as junior engineer works in Tinsukia Division NF Railway. While working as such, he came across an advertisement issued by the All India authorities for filling up of various posts. So he submitted an application seeking NOC. That is on 26/7/2025, praying for appearing in the examination. Well, that NOC was kept pending. In the meantime, All India authorities allowed the petitioner to appear in the examination. Results were declared, he got selected. There were 11 posts. His merit position was serial number 3. 19/1/26 is the date for document verification. The railway authorities forwarded the application seeking NOC from the division to headquarter railway on 12/1/2025. And on 19/1, when the petitioner appeared before the oil authorities asking for some more time for production of NOC, the oil authorities will not intended to cancel his candidature. Under such fact situation, my lord, the petitioner approached this court and this honorable court was pleased to pass an order protecting the candidature of the petitioner. Now, the railway authorities has passed an order pursuant to direction of this honorable court rejecting the grant of NOC. My lord, that order has been challenged by the petitioner before the learned tribunal, my lord, since jurisdiction lie with the tribunal. So that will be taken up, my lord, in a short while. So that is the situation as of now.
But
So they'll have to file the affidavit, my lord.
Your representation has been rejected.
Yes, representation has been rejected. My application has been rejected, and that is challenged before the learned tribunal by filing a OA, my lord. Because I cannot, against an order passed by the railway, I cannot approach this honorable court, my lord. The court of first instance is the tribunal. So within a month, my lord, that can be disposed of, my lord.
Bring it on record.
Let them file their affidavit.
Third council to parties, the respondent will endeavor to file the affidavits within 2 weeks.
Lordship, 2 weeks. Lordship.
It's again, agreed to 127th.
Yes.
Lordship, I am appearing for response 2 and 2. Response 2 and 2.
Now, can it be first week of March, my lord?
9th of March.
Fine, man. Fine.
Much obliged.
So the interim may continue.
The orders passed earlier, if any, will continue. Till the next day fixed.
Yes.
Lordship, I am praying for 2 weeks' time, Lordship, to file affidavit.
MSD Bora, Learned Council for the Health, prays for 2 weeks further time to complete the instructions. Mr. AMS Mozumdar, Learned Council for the Recruitment. Please again after 2 weeks. for 3 weeks. 16th March.
Lordship.
My lord, my petition relates to the non-payment of my family pension due to me on the death of my husband 6 years ago. By order date of 2nd February, this honorable.
What instructions?
Well, in this case, I have telephonic instruction. My first wife and her son, they also claim pension.
Huh?
Petitioner is the second wife. First wife and her son also claim pension.
If gave,
Pension. They have also claimed.
they've claimed.
Minor.
It has been released.
No, minor. Because of that, department is not able to release the pension.
My lord.
If lordship may produce page 91,
The divorce.
From fifth flight instead on 14 November
But you have not
2020.
made them parties.
My lord.
You have not made them parties.
She ceased to be wife of the deceased, as because the first wife was a divorced wife of the deceased on dissolution of the marriage by court decree of the court. The deceased person.
What about the son?
I have no objection to pay the pension as per rule. Or rule 143 of the pension rule says the family pension combining the family constituting the wife, minor son, and dependent unmarried daughter, and therefore he is.
Where is the decree?
My lord, at page. Decree at page 34. This is decree and the order is at 24. Annex of 4 and 5. In this regard, earlier a writ petition was filed, which was annexed, which is annexed here with as annexure 12 at page 61. Wherein this honorable court also confirms the fact. Now,
No appeal was filed.
no mind.
Then she's the divorced wife.
But her son is there,
So son, you decide if he is eligible.
He is
If he is
eligible to get it
portion the pension.
till attainment of his marriage.
After a week, I may be allowed to take written instruction. They have, this is my telephone instruction only.
Mr. D.K. Kotoki appears on the petitioner. Ms. S. Sutia, learned counsel, hearing for the respondent submits that he would like to complete her instruction in the matter, please, for a week's time. Mr. B. Chakraborty for Accountant General. Mr. Kotoki submits that the petitioner is the second wife, but legally wedded wife of the
Yes.
of the petition of late so and so Ramesh Sahu. Stop earlier. Her husband, late Ramesh Sahu, was married to
Mala Sahu.
Mala Sahu.
Alia.
What is the name?
Mala Sahu.
Mala Sahu. Their marriage came to be dissolved by an order passed the date of the order 28th February 2006 by the additional district judge Gauhati. A copy of this order is enclosed as Annexure 5 to the writ petition. The counsel for the petitioner therefore submits that she, being the lawful wife of late Ramesh Sahu, the pensionary benefit from having released. The learned state counsel submits that she has received telephonic instructions that there is a claim raised on behalf of the son born out of the marriage between late Ramesh Sahu and Srimati Mala Sahu. She, however, submits that she would like to complete her instructions in this regard. List again on 16th.
My lord, 16th. My lord,
16th February.
my lord, 16th and 17th maybe,
20 February.
my lord.
With Section 11 petition for appointment of an arbitrator, Lordship. And there are two grounds for appointment of seeking for appointment of an arbitrator on the basis of two grounds. Lordship, first the notice was issued invoking arbitration clause, and arbitrator was not appointed. After filing of the petition, they are issuing for, as per the procedural law, that they're seeking for the arbitrators from among their own arbitrators. And secondly, Lordship, the procedure which is followed by in appointment of the arbitrator, that itself is biased and in contravention with the legislation. So under Section 12, as Lordship, this is the grounds. The work was completed.
Who's for the railways?
Hello.
Yes. 63, 64.
Yes.
Huh? Already answered for so many matters. But have you filed your objections with that?
Yes, my lord.
Where are your objections?
My lord, my lord,
Objection filed.
yes, my lord. It is, my lord, on 27th February 2020. We have said that we have given him a letter, my lord.
Where is the objection that it is 63, 64 and all these are not applicable? Nothing there. You have given him a letter, suggested the name of 4 officers,
My lord.
requesting him to name 2.
My lord.
Now in view of 12.5,
Well.
unless there is a waiver,
Well.
end of the matter.
Well. Yes, my lord.
That's it.
My lord. One thing is, my lord, there, my lord. My lord, there is a provision, my lord, that they should raise this, my lord, claim, my lord, immediately after 120 days, and between 120 days and 180 days. My lord,
All these will be examined.
my
by
lord,
the
that
tribunal
may
to
be, my
raise
lord,
whatever
taken
is
care
there.
of, my lord. Only that too, my lord.
Heard.
And my lord, there is one more thing, my lord. My lord, it is more, my lord, the condition is that if there is more, the amount is more than 10 lakhs, then there should be 3 arbitrators, my lord. So, my lord, my humble submission is that, my lord, 11.3, my lord, as per 11.3 of the Arbitration and Conciliation Act, my lord, failing an arbitration, my lord, 11.3, that may be considered, my lord.
(11.3).
My lord.
What is there? 11.3.
My lord, failing any agreement referred under subsection 2 in an arbitration which 3 arbitrators, each party shall appoint 1 arbitrator and 2 appointed arbiters shall appoint the 3rd arbitrator who shall act as the presiding arbitrator.
So, but the agreement was there.
My lord,
Agreement is there.
my lord, yes, agreement is there, and as per agreement, my lord, if it is more than 10 lakhs, my lord, the claim, my lord, it should be a 3-member arbitrator, my lord.
What is the amount?
Lordship, once amount is more than 10 lakhs.
More than 10 lakhs.
Yes.
So it will be 3 arbitrators.
Lordship, that was a procedure in the, as per the Arbitration Act, provision in the contract. Now, but Lordship, it also says in 11.5 that if the petitioner fails, if the parties fails to agree.
Parties have failed to agree, but
That's it.
the contract agreement prescribes 3 arbitrators.
3 arbitrators.
So their failure is to appoint their arbitrator.
That's it.
Will it amend the clause? It is
Yes.
only a deficiency on their part. The clause remains.
But this does not bar, once we are before the honorable court, because then it does not bar the honorable court to
Does
take
not
its.
bar, but why don't we go beyond the contract?
Exactly.
You agreed with the contract that there should be 3 arbitrators.
Yes, Lordship.
But the only problem is that you have now lost your right to nominate your arbitrator.
My lord, yeah,
Have
my
you
lord,
nominated your arbitrator?
not nominated. Then, my lord, we can choose, my lord, as per this argument also, my lord,
No,
act
now,
also, my lord, we can, my lord, appoint one, my lord.
May I-
arbitrator, my lord.
You can't appoint
Yes.
now.
My lord, but my lord, this, the judgment of my lord, the 5 judgments, my lord, there is no bar, my lord, keeping, my lord,
No,
one,
There is a judgment prior to that.
my lord, 5 judgments, my lord, a person to my lord, 4.
Don't argue matters unless you are sure that you have studied the law. It creates problem because we are not here to educate you. I only have to accept your argument or reject it.
My lord, this is my submission, my lord.
Submission is contrary to law laid down by the apex court. That's what I'm trying to tell you. Heard? MS so-and-so, M. Jain. Petition, and Mr. G. Planning Council release this application is an application filed under section 11.6 of the Arbitration and Conciliation Act. By where is the work order?
for the Lordship. Annexure 1, page 19, Lordship.
By order dated 6/10/2003. 2003.
Yes, Lordship. And the work is completed in 2009, Lordship.
The petitioner was awarded a contract for so-and-so to underline Gora, page number 19. And
My lord, one more thing, my lord, one thing, if you are lordship, can you allow me, my lord?
thereafter, an agreement was executed by and between the petitioners by agreement dated 1/12/2003. And in terms of, where is the clause?
Arbitration clause, Lordship?
Yes.
Lordship, page 41, Lordship. 46, Lordship. I'm sorry, Lordship. 46.
41. 41.
46,
the
Lordship. 46, I'm sorry.
46. As per clause 64, there is a provision for arbitration. The work was duly executed completed by the petitioner in the year 2009.
Yes, Lordship. I tell the date, Lordship.
Then thereafter
34, 2009.
34.
34.
2009. Thereafter, the certain disputes arose with regard to the bills, payments. Payment required to be released to the petitioner. The petitioner
May I interfere, Lordship?
the arbitration clause.
There are 3 claims, Lordship.
There are
3 claims.
Oh.
Basically, the work was completed in 2009. After that, the maintenance period was also 6 months. That was also completed. but they kept our security till 2016, Lordship, without any reason. And thereafter, the final bill, the measurement of the final bill was given on 2015, Lordship. After that, the PVC bill was made. That was also rejected by them. So those like interest, security, overhead, these are the three things, PVC.
We are not specifying, it is already there in your notice, or where is your notice?
Notice, Lordship, yes. It is annexure 8, page 89.
Page number?
89.
89. Thereafter, the petitioner issued a notice under section 11, ID notice dated September 30, 2019, raising the three claims and in requesting the person to refer the matter for arbitration as per clause 64. Stop. Clause 64, 64(3)(a)(1). Provides that where the claims, all claims in question added together does not exceed 10 lakhs, arbitral tribunal will consist of a sole arbitrator. And where the amount is more than 10 lakhs, then the panel shall comprise of 3 gazetted railway officers, not below the rank of JA grade, as arbitrators. The railways will send a panel of 3 names, which are to be, out of which 1 officer will have to be suggested by the, chosen by the petitioner contractor. However, pursuant to the amendment, they have brought in the statute to section 12(5). The petitioner did not invoke its waiver and choose the names suggested by the railways, and instead requested the railways to nominate its arbitrator. You did not suggest the name of any arbitrator in your notice.
No.
Then how will they concur?
No, Lordship, by the Honorable Court, if now it is, the Honorable Court will.
Be that as it may, in terms of the subsequent amendment brought to Rule 12(5), the statute mandates that unless a waiver is provided, unless there is a waiver, the names from the curated panel suggested by the employer cannot be the basis for proceeding appointment of an arbitrator. Strong. That apart, the said position in law is has been specifically laid down by the apex court in the core judgment, CORE core. Under such circumstances, there was a failure on the part of the railways to appoint their to concur and appoint on the arbitrators. There was a failure on the part of the railways to insist. I want to know, there's a failure on the part of the railways to insist on the waiver by the contractor for appointment and selection and appointment of the railway authorities. In view of the law laid down by the apex court, the insistence of the railways appear to be contrary to the law laid down by the court as well as by the amendments brought into the statute under section 12(5). So accordingly, this court now proceeds to appoint arbitrator.
Malad, one more thing, Malad. Malad, my prayer may be rejected, Malad.
Yes.
Malad, my prayer, Malad, I have made a prayer, Malad. As per Malad, the provision of the Malad agreement, as per Malad 11(3), Malad, I prayed for Malad a 3-member panel, Malad, and that may be rejected, Malad. Only that, to that effect, Malad. One line, Malad.
We are appointing a 3
Malad, a 3.
We are appointing 3 members. 2 members we are appointing, they will appoint somebody. Because that is what the contract says. Contract agreement says it is more than 20 lakhs. 10 or 20. 20 lakhs.
But Malad, this Malad 11(3) says, Malad, we can keep Malad independent arbitrator, we can give Malad. That is no bar, Malad.
All right, you appoint your independent.
Yeah, Malad, we'll give one Malad, they will give one, and then.
One thing, once we approach the honorable court, once the parties approach the court,
Actually, they lose the
so
right.
the parties forfeit the right to appoint. Lordship, now it is the prerogative of the honorable court to appoint either the 3 arbitrators or the 2 sole arbitrator. So it is not under the section 11. It does not say that once the parties fail.
Malad,
it
there is a Supreme Court
they forfeit
judgment,
their
Malad,
right.
Malad, where Malad 3-member arbitrator was appointed, Malad, and that is going on, Malad.
Don't just throw names. Which judgment for what?
Malad, I'll give Malad.
What do you mean you'll give? We are in the middle of passing an order. Why is the judgment not here if you want to rely on this?
Malad, after Malad, 10-15 minutes maybe given, Malad, I'll bring that judgment, Malad.
This is no way to conduct.
Malad, I'm sorry, Malad. Malad, I'm sorry,
Being
Malad.
sorry doesn't help.
Malad, I'm sorry.
Your
I
being
should
sorry
have.
doesn't help.
My apology, Malad. I'm sincere apology, Malad. I should have brought
Perhaps
that.
you should permit the railways to draft the order and give it to the court as per your satisfaction. That would be easier. In terms of the provisions of the contract, there is in the event the claims are beyond 20 lakhs, 3 arbitrators, 2 arbitrators are to be appointed by either of the parties, and they will appoint. No, the tribunal is to be consisted of 3 arbitrators. So in that view of the matter, this court now proposes to appoint 2 arbitrators. We'll appoint from the retired district judges. So we appoint Mr. Mrinmoy Kumar Bhattacharya, retired district judge. Who sort the and a person. Mr. Mrinmoy Kumar Bhattacharya, retired district judge, was appointed as arbitrator of the petitioners, and Mr. Anikanto Das, advocate and former Chief Engineer and Secretary to the Government of Assam PWD act as the arbitrator for the respondent. The registry will communicate a copy of this order to the respective prospective arbitrators appointed. The arbitrator's appointment will be confirmed subject to receipt of the written declaration required under section 12(1). Stop. Once the appointment of the prospective arbitrators is confirmed, both the arbitrators will thereafter proceed to appoint the third arbitrator. Later. Now we are appointing two.
Yes. Okay.
List again after. List again on. March. 13 March. And appears for the petitioner on this. MS.
Ji Sarma.
D. Sarma.
Ji Sarma.
D. Sarma appears for the legal. Matter stands again to be listed after 1 week. Yes.
Made result. My lord, the petitioners are all A&M nurse. My lord, they are paying for pay parity, my lord. With the regular ones. Now, my lord, the affidavit has been filed by the director, my lord, where the director do not deny anything.
Pleadings are exchanged.
Pleadings are there.
We keep it for.
My lord, my only submission is, my lord, if it is not otherwise inconvenient, could it be, my lord, 25th or 24th, my lord? I think 20.
We can have it on 20.
Or 26th, my lord.
This is for admission.
Admission hearing. My lord, it's not a very longish matter, my lord. Only thing is I'll have to place few judgments. And I'll have to satisfy that that the onus lies on me.
All right, 26th.
Yes. For final disposal.
Since the pleadings are exchanged, the matter is fixed on 26th of February. Attempt will be made to finally dispose of the petition.
Much obliged. Deeply.
My lord, this was pertaining to correct pay scale of the petitioner. Lordship had heard that the matter some land on the other day. Then I was asked to, my lord, actually produce a sheet, basically chart of the different pay matrices and different, my lord, the increments that the person has got. I had prepared the same, my lord, but then that Excel file, my lord, suddenly I found that it is corrupt. Today I could not place it. I need, my lord, a week's time, my lord, to place it again. That will clarify the whole issue as to how his pay had progressed.
Counsel prepared for the petitioner submits that you would like to place on record the pay metrics, relevant charts regarding the pay metrics. He prays for a week's time. It is forward, it is for the then the CDC appears for the state. This again on.
Can it be possible to fix March, first week of March, Lordship?
First week is Polias and then second week.
Learned CDC submit that the matter be listed on the first week of March.
Second week of March.
Matter be listed in March. Accordingly, the matter stands deferred to be listed on 12th of March.
My lord. Keep clear.
Oh, in 41, the otherwise pleading is completed. My humble prayer for losses, can it be in a hearing day, my lord?
What is the objection? Railway.
Not railway, Malad. MES, Malad.
Military engineering.
All right, then have it on a hearing day. The parties submitted the pleadings are complete. Therefore, is agreed to list the matter on 12th of March. Attempt would be made to dispose of the matters on both the dates.
Well, 42 is it.
Mr. Goswami appears for item number 41.
41, Malad.
Mr. Upai Odhikari for 42.
Fine.
Oblige.
Yes.
My lord, my lord, for a moment, my lord, may kindly come to page 12, my lord.
So first tell us what is the matter.
So my lord, there was a mistake in the certificate, my lord. While issuing the boiler certificate, it was mentioned as Bachelor of Science.
What are you here for the court? Why have you come to the court?
My lord, they have issued an advertisement, my lord, and then I was disqualified
Advertisement for what?
for the for a post of junior assistant, my lord.
Junior assistant.
No, on this advertisement.
Yes, then
For a post of, my lord, junior engineering assistant, they have issued a advertisement, my lord. I had applied and I was disqualified. Why I was disqualified? They said that I don't have certificate for boiler attendant, my lord. I have done the course, my lord. After doing the course, a certificate was issued to me. In that certificate, they have committed an error. They should have written boiler attendant. They have given it under Bachelor of Science. Then, my lord, there were communications made by them to the concerned authorities to correct it. And we have also filed this writ petition. And in the writ petition, we have a prayer also to ask them to correct it. Now, my lord, this was going on, my lord. Now, they have issued the certificates, my lord. The second prayer is, my lord, already, my lord. It is dealt with. And my lord, I have given the certificates, my lord. Recently, my lord, after the last date, my lord, they have issued us the certificate.
bring it on record. And this is one of your prayer.
Yeah.
Is it enough to close the writ petition?
My lord, since this is, my lord, already there, now I have got the corrected certificate, my lord. So first prayer also can be allowed, my lord.
First prayer, what is the
Yes.
first prayer? Directing respondents to call the so-and-so for skill and physical test.
Yes, because there is a next stage. And my lord,
This selection process is still going on.
yeah, two-stage process. This is a final step. And my lord, the petitions before your lordship, my lord, are very meritorious students, and the marks obtained by them, my lord, in the first stage, my lord, suppose highest is 67, one of them got 66. There are 10 posts. 4 are there for general category candidates. Anyways, my lord, he will be selected, my lord.
Yes, Mr. Deka, what do you say?
I have to make my submissions not like this, because ultimately it's a question of eligibility on the date of the advertisement, the date prescribed in the advertisement, they were not eligible.
Certificate was there or not?
It was not there.
This specific
And the
arguments, my lord,
certificate is not issued by me, my lord. They have done the apprenticeship in the Indian Oil Corporation. The certificate is issued by the authorities concerned, not by the IOCL.
You want to bring it on record or?
I don't have a copy, my lord.
I'll bring it on record, my lord. My lord, regarding this submission, my lord, last time also when this matter was heard, my lord, another court, my lord, the same submission was made. We replied, my lord, detailed reply we have given on 2 occasions, 2 days, on this point only, my lord, it was heard. And the court, my lord, on that day, my lord, said that we'll not go by this, not eligible, because we have made our argument why that cannot be. Now, my lord, again, same argument is coming up, my lord.
Then why was it not kept parted?
That's what, my lord.
You did not press for
Our
it?
bet.
It was not heard at such, my lord.
It was
Instructions,
heard,
after hearing the matter, instructions were sought, my lord. Then I have filed my additional affidavit,
Right.
bringing on record those instructions.
The counsel for the petitioner submits that the certificate required to be issued for certifying the proficiency under the National Apprenticeship Training Scheme has been rectified and issued afresh. Stop. He therefore submits that the prayer number 2 in the prayer number 2 in the writ petition has been redressed and he does not want to press the same. So, insofar as prayer number 1 is concerned in the writ petition, he submits that in view of the certificate, rectified certificate issue, the authorities should now proceed to call the petitioners for skill, proficiency, and physical test verification on the basis of the rectified certificate. Mr. N. Deka, on the other hand, strongly opposes the submissions made. Strongly submits that the petitioner's qualification is to be adjudged on the basis, on the last day of, on the day when he has filed the.
On the date specified in the advertisement.
The date specified in the advertisement. Specifying the dates for submission of the
consideration of the eligibility.
Consideration of the eligibility. So, the rectified certificate has been supplied to the petitioner only recently, well after the date specified in the advertisement. Therefore, this rectified certificate may not be considered by the petitioners, respondents, to be a valid ground to issue, to call the petitioners for proficiency test, etc. So, he, however, submits that the rectified certificate has not been supplied to the respondents. Mr. Ahmed, counsel for the petitioner, submits that you would like to bring it on affidavit. Bring the rectified certificates on affidavits. Accordingly, let this matter be listed after 2 weeks, enabling the petitioners to bring the rectified certificate on affidavit.
May I make a submission, my lord?
Yes.
There are interim orders, my lord, prohibiting us from filling up the posts. So can a fixed date be given, my lord?
Released on 25th of February.
And my lord, on 27th of January 2026, they had the respondent number 1 and 2 have filed additional affidavit. We want to file a reply to that affidavit also.
Do it by 25th.
Yes, my lord, that may be allowed.
The petitioner is also permitted to file reply affidavit to the affidavits filed by the
Respondent number 1 and 2.
respondent 1 and 2. Then we fix it on 26th of February. We take back the origin.
My lord,
Take back the origin.
I'll take back mine. Oblige, my lord.
Lord, pertains to dismissal from service, my lord. The pleadings are complete otherwise.
Lordship, I fix it for hearing, Lordship.
Hearing. Then we'll have
Admission hearing, my lord.
Huh?
Admission hearing some other day. Hearing it never comes, my lord. Short issue, my lord. Whether procedure was
It
complete.
comes, but it comes subject to there is a lesser number of admission.
Yes, yes.
So
That
if
also is, my
at
lord.
the
it is-
heart of the admission stage, then how will he?
My lord, the issue is very short, my lord. Whether procedure was followed.
List this matter on 10 March.
My lord.
As it is submitted, that the proceedings are completed and the matter can be taken up for hearing. Sorry, not 10, 12. 12 March.
Obliged.
Yes.
My lord, due to-
Affidavit file.
my lord, affidavit file, my lord, due
You
to
want to
14
file
days,
rejoinder?
we'll file, my lord.
You file.
Not yet filed, we will file.
File
Sometime.
it.
Only 14 day in absence, my lord, my service has been terminated.
You want to file? Or
Yes, madam.
You want to file it, all right. The respondents have filed their affidavit in opposition, to which the petitioners submit that they would like to file their affidavits in rejoinder. The
2 weeks.
counsel for the petitioner prays for
2 weeks. ma'am.
2 weeks' time. List this matter on 12th March.
Deeply opposed.
My name may be recorded
Mr. Onikari's
for all the respondents.
name he appears for all the
Yes,
respondents.
obliged.
9 March, my lord, my prayers.
9 March is not possible.
Yes.
12, 19.
15 free.
Yes, Lordship. Case of the petitioner, my lord, the petitioner for recruitment of my lord, sorry, for CRPF, BSF, my lord, conducted by the State Selection Commission, my lord. He has passed, she has passed the written test, my lord, and accordingly, physical standard test and physical efficiency says she has overcome, my lord, passed, my lord. But she did not issue the call letter, my lord, for medical examination, my lord.
He has not attained the, received the cutoff marks, Lordship. He get less marks in computer-based examination and in physical standard test, he has not qualified, Lordship. I have received the instruction and record, Lordship.
I have annexed the certificate of physical test, page number 49A, my lord. Annexer 7, page number 49A. My lord, here, my lord, the petitioner is qualified, my lord.
This is physical eligibility test.
Physical,
Measurement of height chest by the appellate authority, my lord.
Where is it is mentioned?
subject, measurement of height, chest.
Reassessment, that is, he was
Reassessed.
not reassessed and he was not qualified, Lordship.
Why was he reassessed?
Yes, record is there available, Lordship.
But why?
His height was not not as per the guideline, Lordship, advertised notice, Lordship.
No, height is 151.7.
Yes, my lord.
What is the, as per the notice?
As per the
12
notice, my lord,
point-
page number 29, the guideline is there, my lord, advertisement, page number 29, my lord.
He is OBC category, Lordship.
My lord, she
29.
belongs, yes, my lord.
Yes.
She belongs to SC category. My lord, while she submitted the application, it is shown OBC. But subsequently, immediately after coming to know that it is shown as OBC, she went to Delhi head office, my lord, and it was rectified, my lord.
But as per our guideline, Lordship, that
157 is the required,
Yes, my lord, I have,
but where is the OBC height
my lord, for
OBC?
12.5.1.3.
my lord,
For
page
OBC,
29, my lord, B, my lord, all scheduled tribe candidates, northeastern regions, my lord, female candidate 147, my lord.
Huh?
no, OBC
147.5.
is,
No, you don't belong to scheduled tribe.
Yes, my lord, I have,
All scheduled tribe candidates. You are not a scheduled tribe.
oh, it's a scheduled caste, my lord. I have annexed the certificate and my lord, I have just
Hey,
furnished.
you show us from the chart. Under which category you fall?
My lord, all candidates belong to scheduled tribes here only, OBC
Scheduled
is not,
tribe, you're not a scheduled tribe.
yes, my lord, yeah, here it is not mentioned, my lord. Even my lord, I have qualified, my lord.
These are your documents.
Yes,
You
my
have
lord.
enclosed.
Yes, my lord.
If it is not mentioned here, then on what basis are you claiming that you qualify?
My lord, female candidates, my lord, category A 150, category B 147, my lord, I got, my lord, 151.7.
Category A
My lord,
is scheduled tribes.
yes, my lord. My lord, let them file the affidavit since they have.
No. Necessarily you are dragging matters. What is your name?
AM Ruby, my lord.
Huh?
AM Ruby. AM
Ruby.
Ruby, yes, ma'am.
he applied online application as OBC category, Lordship. That instruction is here.
It is
all
rectified.
all instruction is, record is available with me, Lordship. For OBC
You
candidate,
belong to scheduled tribe.
Yes, scheduled caste, my lord.
Then scheduled caste is not here. In the chart. Where is the mention for scheduled caste? Not here. Where is the scheduled caste? Even if you belong to category E,
My lord, candidates have.
it should be 152. So we dismissing your petition.
It is state of Arunachal Pradesh, Manipur, not Assam, included, not Assam. E, my lord, category E, Assam is not included.
So what about Assam? Where is it there?
D.
Hmm?
D, Lordship.
E does not include Assam.
Yes,
E not,
include, my lord.
A, B, C, D, D for Delhi.
Then
Candidates
D,
falling the
my lord, here
categories
D is-
Gauhati, Rupgras,
155.
Yes, Lordship.
155. Assam is there. Yes.
My lord.
So you don't satisfy the criteria.
I think here not mentioned OBC and SC, only scheduled tribe is written, my lord, in the
So you don't belong to
advertisement.
scheduled tribe. Have you mentioned anywhere that you are a member of the scheduled tribes?
Not scheduled, scheduled caste.
Huh?
Scheduled caste.
Scheduled caste
Yes.
is not here. In the chart, there is no reference to scheduled caste.
Yes, my lord.
So how are you claiming the benefit of scheduled tribes? You're not a scheduled tribe.
I can take, my lord, benefit of scheduled tribe.
In the state of Assam, it is 155, you are 151.
And merit list also, he was not selected, Lordship. He get less marks than cutoff marks, Lordship. Here on first page, that is mentioned there. Yeah, on computer-based examination, he get less marks than cutoff marks, Lordship.
Computer based.
Yes.
It is before the
Examination held before the physical test, but the result merit list declared after that, Lordship.
That is the final merit. Final.
All right, so we are closing your petition. Heard by counsel for the petitioner, the present writ petition. This writ petition is filed by the petitioner.
It will cost open result. It will try to defense.
By this petitioner participated in the selection process in the post of Constable General Duty in terms of advertisement dated 5/9/2024, issued by the Staff Selection Commission. So, according to the petitioner, she had passed the written test and then appeared for physical standard test and physical efficiency test. So her roll number assigned was 5401-003519. However, in spite of her successful completion of PST and T, the petitioner was not called for her medical test. So she submitted her representations praying for her, permitting her to appear in the medical test. But the same was not responded to, being agreed, the present writ has been filed. Have you filed any affidavit here?
No, Lordship.
Learned CGC. If the MSS Purva appearing for the petitioner submits that although the petitioner had appeared in the PET and EST test, she obtained lesser marks in what is the CBE?
Computer-based examination.
Computer-based examination below the cutoff marks. Although this computer-based examination was conducted prior to the PST and PET, however, the results were declared after the results of the PET and PST. Is that so?
Yes.
No, man. Before physical test, my lord, computer based result was declared, my lord. Then physical test, medical test come, my lord.
All right. 8-line strike of holding. The instructions received by the London CCC shows that the petitioner had received 71.01078 in the computer-based examination when the cutoff mark for the same cutoff mark is
75, I think, on,
oh, don't think, be specific.
that is here,
Go and show it to us. The cutoff mark is so and so.
the instruction.
Tick mark করে দিব. Stop. That apart, upon perusal of the writ petition, it is seen that
71.01078.
that is what she has received.
No, cutoff marks. And she obtained 56.82.
71 is the cutoff mark.
Yes.
And she received 56.829.
6.829. Oh, yes.
This is the part of the advertisement. This is the advertisement, right?
Yes, sir.
In the advertisement dated 5/9/2024,
Yes, sir.
the height in respect for physical standard tests, the standard height for different categories is specified. Page number 29 or 18. For male, generally for males, it is 170 cms, and for female, it is 157 cms. However, few categories of candidates are allowed relaxation in heights, which are provided in as under a chart to do. So, para. Insofar as the writ petitioner is concerned, her height was found to be 151.2.
Yes, 7 minor.
7. 151.7.
Yes.
This
Here it is written in the certificate, found eligible. Found qualified. Page number 49A, my lord.
and stop. In the certificate, however, it was mentioned that the petitioner was found qualified.
You could qualify it as a not qualified.
In the
chart,
the chart which is mentioned in the advertisement at clause 12.5, it's seen that in the categories mentioned, the petitioner does not fall. She is not a dual tribe from the northeast. She is a person of a schedule belonging to a scheduled caste. Stop. There is no relaxation in respect of scheduled caste members. Stop. Insofar as the candidates from Assam is concerned, the height prescribed for a female is 155. Therefore, it is not understood as to how the petitioner could have been considered qualified under 151.7 centimeters of height. Be that as it may, even if his certificate is considered to be qualified, the petitioner did not clear the computer-based examination, and as discussed, she had secured
56.82.
marks out of total of 71 points. So 0.
Yes, cutoff mark is 71.0.
Such set of that, we find no merit in the writ petition. Accordingly, the same stands dismissed. No order as to